Good morning, ladies and gentlemen. It's a great honor to guest you here in Krakow, and I give word to our dean at the beginning.
Good morning, ladies and gentlemen, dear colleagues, dear guests. On behalf of the authorities of the Jagiellonian University Faculty of Law Administration, I would like to welcome all of you to our university, to our faculty, and to this conference in particular. I'm a modest human rights lawyer, but I see from the program, and I'm very happy to see that this conference combines theoretical and practical approaches to law. And this is the approach I value the most. I always repeat that both legal research and legal academic education are much more effective if supported by practical approaches and experience. And this is especially true if they are internationalized. And this is the case as far as this conference is concerned, so I especially would like to welcome our foreign guests. I'm happy you are here with us. And also I would like to thank our partners, external partners, practitioners present here and online. Let me also say that I find this conference very timely, especially as one of the panels will deal with the growing importance of artificial intelligence for judicial case management. And indeed, this is artificial intelligence is creating the new reality for lawyers as well, including the academic legal education. Let me just say that just 2 weeks ago, I had a chance to take part to attend a meeting of the Law Deans group within the Guild Academic Alliance in Ljubljana, Slovenia. And we discussed the use of AI tools in academic legal education. And I have to say that some law schools, such as Bologna, such as Groningen, already require their professors to use AI tools in academic classes. It's not an option. It's not an encouragement. It's an obligation. And I think this is the new reality, and also this is the new reality for practitioners. So I wish you all a very successful conference, and I hope to see you again in Krakow. I'm really sorry I have to leave you soon, but I hope you will enjoy the conference and your stay in Krakow. All the best.
Ladies and gentlemen, joining the words of our dean, I would first of all like to thank our distinguished speakers for accepting the invitation to our conference. I would like to thank the co-organizers of our conference, the Institute of Justice in Warsaw, represented by the director, Professor Piotr Rylski, the Krakow Bar Association of Attorneys at Law, represented by Dr. Magdalena Romanowska, and KKG Legal, Kuba Skos-Gałkowski, our generous patron. I would also like to thank my colleague from the Department of Civil Procedure, Professor Andrzej Olech, the initiator and the coordinator of the conference. And I wish us fruitful deliberations. And I have a word to Professor Piotr Rylski.
Ladies and gentlemen, Professor Fleischer, thank you for introduction. It's a great pleasure for me and a great honor as a director of the Institute of Justice in Warsaw to open today's conference. This conference, as we know, is organized by the Institute of Justice, the Jagiellonian University, the host of this place, and the Krakow Bar of Attorneys at Law. I'm particularly pleased with the topics chosen for this conference, which combine tradition with modernity, the past with the future. On the one hand, we will discuss the concentration of evidence and facts. On the other, the use of artificial intelligence in civil proceedings. Both of these issues are fundamental to civil proceedings. Firstly, because facts and evidence form the basis of every court decision. The right to an efficient resolution of a case and the correctness of the decision to be made depend on the proper regulation of issues such as who and when should present the necessary facts and evidence. On the other hand, with the development of technology, the question arises as to the limits of the use of AI in the management and even adjudication of civil cases. I am convinced that today's conference is an excellent step towards further scientific research in this field. Both mentioned issues are also close to the mission of the Institute of Justice in Warsaw, which I have the honor to lead. We realize that reliable analysis of the status and condition of the justice system should serve to improve its quality. This year, the Institute celebrates its 35th anniversary. During this period, it has provided numerous analyses and reports on the state of the justice system in Poland and indicated possible directions for improvements. Currently, it also conducts extensive empirical and comparative legal research in the field of justice. In particular, the Institute's research relates to court proceedings, including civil proceedings. The Institute is the only institution in Poland that conducts large-scale research into court practice by analyzing court files. This allows us to evaluate the functioning of the institutions concerned and make proposals for legislative amendments. I believe that today's conference marks the beginning of cooperation between the Institute and its partners on the direction of changes in civil procedure with a view to improving and enhancing the quality of justice. Thank you, and I wish you productive discussion and an excellent conference. Thank you very much.
Please, some words to our last partner, Dr. Magdalena Romanowska, please.
Good morning. My name is Magdalena Romanowska. I'm attorney at law, member of the National Bar Council of Attorneys at Law, and member of Krakow Bar Association of Attorneys at Law, that is one of 19 regional bar associations in Poland. The Polish Attorneys of Law Association is over 40 years old. There are over 50,000 attorneys at law, and Krakow Bar has 4,500 members. Regional bar associations are responsible primarily for representing the professional interests of its members, running legal training, continuous education of attorneys at law, supervising the practice of the profession, and keeping the list of attorneys at law, foreign lawyers, and trainees. I'm happy to report that Krakow Bar Association is cooperating closely with Jagiellonian University, and many of its members are also academics. Within the Krakow Bar Association, we have an international cooperation committee that main purpose is carrying out policy of foreign cooperation, including initiating and maintaining cooperation with foreign counterparts and universities. Today's conference has a significant value, as the concentration of facts and evidence in civil proceedings lays in the center of work of every practicing attorney at law. The aim of this rule is clear: to accelerate and to streamline court proceedings. But is it really working? I'm very pleased that it will be possible to learn about experiences in this scope from different countries. Artificial intelligence, on the other hand, is here and it will stay. We need to be ready to use it in our professional life. It presents many opportunities like work simplification, faster data analysis, and even tools to create documentation. But still, it requires to be better understood. Also, in case of court proceedings, there are questions about data confidentiality, as data is used to improve models. Still, and by we I mean people and artificial intelligence, need to learn how to get accuracy, clarity, completeness, and appropriate tone suitable to legal proceedings. Attorneys at law, we are also exploring artificial intelligence possibilities and risks. In Poland, we are at the beginning of this road, and this conference is a valuable source of knowledge that might be used in our country. I'm looking forward for today's exchanges and further close cooperation in the future. Thank you.
Thank you.
We start with the first panel, the splendid topic of this first panel, the concentration of facts and evidence, past, present, and the future. It's a very great honor to be chairman of this panel and to cooperate with such great reporters. So let me introduce our reporters for this panel. As you see, we've got two parts of this panel: before coffee break and after coffee break. It means that we will taste this topic gradually. We start with the Swiss perspective. I've got next to me Ms. Professor Tania Domey from University of Zurich, who will present us the Swiss perspective about concentrations of facts and evidence. And after her presentation, I will invite the Professor Michele Angelo Lupoi from University of Bologna, who will present the Italian perspective. After the coffee break, we will move to the Spain, and it will be, in fact, moving to Spain because Professor Fernando Gascon in-house will join us remotely, online mode. And finally, the French perspective, Dr. Etienne Nedeyek from Panthéon-Sorbonne University. So, not losing the time, I think that I may give the floor Professor Tania Domey, please.
Thank you very much. Thank you to the organizers for the extremely diligent work that they have done. I'm very impressed, I have to say. So thank you very much. I will talk about the Swiss perspective. I will try not to speak too long so that we maybe have a few minutes left if there are any questions, if that is okay for you.
At the end of the panel.
Okay, good. Well. About the Swiss perspective, so the conference is entitled Past, Present and Future. So maybe you will be aware that Switzerland has not had a uniform code of civil procedure for an extremely long time. In fact, the current Code of Civil Procedure entered into force in 2011. Incidentally, that was the same year when I started my professorship in Zurich. Before that, we had 26 cantonal laws plus another federal law that still applies, but only applies for a very, very narrow range of cases. Already the cantonal laws had some traditions that are roughly in line with what exists now. So there used to be already in the cantonal law some restrictions on the right of the parties to introduce new evidence or new allegations into the procedure. There was a wide variety, but it was like a general thing that there was some restriction. And already at that time, the rule was that the restrictions that applied in the first instance proceedings were somehow carried over to the appeal stage with some differences. And if we look at the specific case of the review, so if reopening the proceedings after a final judgment, there was generally a possibility to do that, but also there was a common trend that newly created evidence could not be a ground for a review of the final judgment. And I think that should be enough just to give you a taste that there was like something that was pretty like close to what we have in today's law. But mainly I would look at today's law and here start with the first instance proceedings. Now we have already had a reform of the relevant rules, and that reform entered into force in 2025. So I'll say a little bit about the previous rules and about the current rules. It was not a revolutionary change that was made with this new reform, but there was some change, and you may imagine that these were changes that were mainly driven by practicing lawyers. Because I have to say that these rules on new allegations and new evidence are not extremely popular with practicing lawyers. That was already a big contentious issue when the Code of Civil Procedure was created. Already then, these rules on new allegations and the details of how they are conceived were a big issue in the parliamentary stage of the lawmaking. I don't know what it's like in Poland, but in Switzerland there are many lawyers in the parliament, and there are many lawyers in the parliament, and some of them are actually practicing litigators or used to be practicing litigators, and that's why they were particularly interested in these rules on new allegations and new evidence, because they were kind of familiar with how that can make their lives more difficult or easier depending on what the situation is, and therefore this was an issue that was hotly debated until the end, and also now with the reform, this was something that was in which lawyers were highly interested, and there were several changes made in the relevant article. The relevant article is Article 229 of the Code of Civil Procedure, and maybe I will just quickly explain how that article works. So today, the article says, if neither a second exchange of written submissions nor an instruction hearing has taken place, new facts and evidence may be presented at the main hearing in the first party submission in accordance with Article 228, paragraph 1, without restriction. So Article 228, paragraph 1 is simply the rule on this first hearing and how it is structured. And the general principle that that is embodied in this article is that there are two opportunities to raise new allegations of facts and to present new evidence without any restrictions. And then the file is closed, it's called. It's not really closed, but it's commonly referred to as the closure of the file. Often these two opportunities actually take place before the oral hearing. So it can be either two exchanges of written submissions, or it is one exchange of written submissions and a so-called instruction hearing. that instruction hearing can have all sorts of purposes. It can be for case management, it can be for settlement negotiations, and sometimes it's also to make it clearer what the parties are actually bringing forward, so to make allegations and to bring forward evidence. And if it is to make allegations and to introduce evidence, if that is one of the purposes of the instruction hearing, then the closure of the file takes place after the instruction hearing. So very often the main hearing is a bit of theater, basically, because nothing new can actually be brought forward in it. And so this is the basic structure. If the second opportunity is in the main hearing, then the parties can bring forward new facts and evidence in their first oral party submission. So this is like, in those cases, you have either only one exchange of written statements, or you have one exchange of written statements and an instruction hearing that is only for settlement negotiations or something like that. And then you have like the oral hearing, and there you have like an oral kind of reply to the first written submission of the defendant, so oral and the duplicate or duplicate of the defendant then takes place in the main hearing. And in those cases, the parties can bring forward new facts and new evidence in these first submissions. And that is one of the changes that was made in this reform in 2025, because before that, there was a case law of the Swiss Federal Court that said if the oral hearing is the second opportunity to bring forward new allegations and evidence in an unrestricted manner, then you have to bring them forward at the beginning of the oral hearing, so before you make your oral submissions. And that was highly criticized by lawyers. They said, well, that makes really no sense. And there were even some, before this case law was created, there was also a dispute about whether it isn't maybe all the oral exchanges at the beginning of the oral hearing and so on and so forth. I personally was not so critical about this case law, because I thought, well, if you have to bring it forward right at the beginning before you make your statements, then it can actually be more efficient, because you then know right away whether there are new submissions, and if there is a new submission from the defendant, it's maybe good to know before you go like on a half-hour rant about the case and suddenly everything is different. So I was actually quite positive about this case law, but now it's no longer there. Now it's in the first oral submissions. And after that, as I said, the case is closed, or the file is closed, but as I already indicated, it's not really closed, because you can still bring forward new facts and evidence, but only in a restricted manner. And I will talk about how you can do that in a moment. So, and also I should note that these are the rules that apply to the ordinary and the so-called simplified procedure in cases where the court does not have to establish the facts ex officio. So if the court has to establish the facts ex officio, then you can bring forward new facts and evidence until the beginning of the judgment deliberation, which is kind of the final, when the final curtain falls, and I will say maybe a few words about that later, about this beginning of the judgment deliberation. So now we're in the stage where you can no longer bring forward new facts and evidence unrestrictedly. And now the current rule is a bit more complicated than it used to be, because the original rule used to be you have to bring them forward without delay, and you have to have a good reason for bringing them up only now, because they are either newly created or you couldn't bring them forward without your own fault. And now there is something that is a bit more complicated. I mean, the reason why this was done, they try to make it clearer when you have to bring it forward, because there used to be a question whether you maybe had to make an additional submission, because as I said, often this closure of the case file took place before the oral hearing. And then the question was, what happens if between this second exchange of statements and the oral hearing something happens? Can you then wait until the oral hearing, or do you have to make a separate submission right away? And they tried to clarify that. I think nobody thinks that it was really clarified, but it was an attempt. So, of course, the law distinguishes between newly discovered facts and evidence and newly arisen facts or newly created evidence. I would assume that probably every procedural system will have this kind of distinction. And if there were newly discovered facts or evidence, then the requirement is that they could not be raised earlier, although the party exercised reasonable diligence. There were some issues to clarify in this context, particularly because of this structure where you have two unrestricted opportunities and then you have a very restrictive rule. So a question that often arose was, what happens if the defendant brings forward something very new and surprising in the second submission? This is something that's referred to as duplicnoven. So in the claimant's second statement, there are new facts or evidence. And for that, the federal court has developed a more generous approach, I think very rightly so, because the trouble with this whole system is, of course, the idea behind restricting new facts and evidence is procedural efficiency, but I think everybody knows that it is a two-edged sword, because having very, very strong restrictions on new facts and evidence obviously means that you will try to bring forward everything, and then the courts will be swamped. And indeed, the Swiss courts are complaining how long the submissions are getting, how much evidence is heaped upon them, and are wondering why that could be. And of course, many people keep telling them that, well, that may be because of the strict handling of these rules on new allegations and evidence. The stricter you handle that, the more the parties will really try to bring forward everything, because that's one of the issues where you could have an easier time than in other cases to also establish liability of the lawyer, and if you lose the case because of that, it's no good, of course. So I think that it's a good thing that at least in this case, if the new facts or evidence are triggered by something that was in the defendant's second statement, there tends to be a more generous approach. There is kind of, I won't say that there is almost a presumption that you couldn't bring it forward earlier, but it kind of goes in that direction. And another thing that's not more generous but more strict is, as I said, there is this distinction between newly or newly discovered and newly arisen facts and evidence, but there are, of course, some cases where arising is something that is under the relevant party's control. For example, if you bring like a new exception, or if you yourself create new evidence, such as bringing now, since 2025, also private expert opinions are treated as evidence, so I guess that could become more relevant. And in that case, the rules on newly discovered facts or evidence apply if it is under the party's control. So you cannot just simply say, well, now I've created this fact and now please treat it as relevant. But I don't think that it's already quite clear what exactly the lengths will be to which the courts will go in that regard. Now, and as I said, the time limits, these were changed by this reform. It's now, you have to bring forward new facts and evidence within a time limit set by the court. And if no time limit was set by the court, you have to submit them by the first pleadings at the main hearing. So now here we have the same rule that was in the original text of Article 2029 that the federal court treated as you have to bring it forward before your oral submission. So, of course, now it's again unclear what exactly these time limits mean, and we'll have to wait for the federal court to clarify that. Also, I don't think I'll go into too much detail of that, because there's now also a rule what happens if new facts and evidence come to the surface after the first pleadings by the parties. It's also unclear what exactly those time limits actually mean, but I think I'll skip that a little bit. What I'll say is this last point here. Oh, can you see that? The last point here, the latest points of an admissible introduction of new facts and evidence, because that is the cut-off date in Swiss civil procedure. It is the beginning of the judgment deliberation, which I think is a bit unfortunate as a cutoff point, because in many codes of civil procedure, I don't know how it is in Poland, but in Germany, for example, you have this end of the oral hearing, Schluss der mündlichen Verhandlung. And there you have a very clear cutoff point, and the parties know that this is really the relevant cutoff point, and maybe, I mean, even in such cases, you can have some kind of reopening or whatever, but in Switzerland it's the beginning of the judgment deliberation, and nobody knows when the beginning of the judgment deliberation is, if it is something purely internal, and the court then just simply surprises the parties by saying, well, but we've already begun the judgment deliberation. So some courts have started making or notifying the parties and saying, now we're entering into the judgment deliberation. They might even theoretically say, okay, now the hearing is closed, or now we have received the final submissions, now we're beginning the judgment deliberation and the case is closed. You could theoretically do that, but there is no prescription in the law. So that is probably one thing that I would really change about these procedural rules, to say there has to be some kind of clear cutoff date, some that would be like a procedural decision by the court. You usually have that in arbitral proceedings, for example, where you have like some pronouncement, some statement, now we're closing the file, now we're closing the proceedings, and you could still enable the court or the parties to bring about a reopening, but it would be clear that the file is really closed now. And unfortunately, this does not exist in Switzerland, and it is further complicated by the case law on the so-called right to reply. I don't know if that has made its way to Poland, but Switzerland thinks that the case law of the European Court of Human Rights requires that you can react to every submission that somebody makes. So you could still react even to the closing submission of the defendant. The plaintiff can still react, and potentially even react with new facts and evidence. And that, of course, can create a lot of uncertainty. And there's also a new rule about that in the Code of Civil Procedure. And that would also be helped by some kind of clear definition of the real closure of the file. Well, I think that should be enough about the first instance proceedings. Just briefly about the appellate proceedings. So there are, of course, comparatively many different ways of approaching new facts and evidence in appellate proceedings. Austria famously has a total kind of does not allow any new facts and evidence, so you would have to proceed in a different way if you have new facts and evidence after the first instance judgment. you would have to ask for like a reopening of the case at the first instance. But in Switzerland, you can't introduce new facts and evidence in the appellate proceedings, and the restrictions are similar as in the first instance proceedings. So the criteria are the new facts and evidence must be submitted without delay, and they could not have been submitted before the first instance despite reasonable diligence. Generally, at the appellate stage, you do not have these two unrestricted opportunities. It's restricted from the very beginning, and the requirement is generally that you bring it forward in your first statements. Even if there is a second exchange of statements at the appellate stage, you still have to bring forward new facts and evidence, generally in your first statements, if you can, of course. I mean, if they only arise later, then you might still be able to introduce them later. Also, there is one modification, which is if there is a strict inquisitory principle. So these are proceedings, there are only very few proceedings in which that applies. It's basically about children. In family proceedings in matters concerning children. So in many places, I don't know what it's like in Poland, but in Austria, presumably these would not be contentious, but it would be non-contentious civil proceedings, and I suppose that probably Poland will presumably have a similar system. So these is not really what we would then treat even in the Code of Civil Procedure, maybe. But in most cases, there are restrictions, and this admissibility of new facts and evidence only concerns appellate proceedings, so proceedings on the appeal called Berufung in Switzerland. There is another appellate remedy, a Beschwerde or objection in certain cases, so against certain decisions, particularly in low-value claims and in against certain types of decisions, and there new facts and evidence are generally excluded, except in certain specific cases like the objection against the declaration of enforceability or a decision that opens insolvency proceedings and things like that, so very specific proceedings, but generally new facts and evidence are excluded in those objection proceedings and also in proceedings before the federal court. In such proceedings, you can only bring forward new facts and evidence if that is triggered by the decision. For example, if you find out by reading the decision that the judge was probably biased, it happens, I've seen it, then you can bring that forward as a new fact. So, and now very briefly, finally, as I said, in the review of the final decision, newly discovered facts or evidence can be the basis for the review of the final decision, of course, only if they already existed beforehand. If new facts happen, then it's not a reason for reopening the proceedings, then it's a reason for a new claim. I think what still remains a question, so the legal text clearly says that new evidence is also excluded. I think that is still unclear whether the federal court really thinks that or whether it might interpret this text differently. At least some cases point in the direction that in some cases they allow new evidence, maybe. And the final question is, well, does this work? Would I recommend to introduce that? Unfortunately, it's totally unclear whether any of this works to make the procedure more efficient. It's totally unclear whether there is any influence of these rules on limits to bring forward new facts or evidence on the duration of the proceedings. I don't think there were big differences in the duration of proceedings in the cantons, depending on how strict they were. Probably some kind of restriction, I think, is good, but I think the main step is already done if the judge has kind of the right to strike out new facts and evidence, and I would probably rather go with a softer restriction than with a too hard restriction, because I think that too hard restrictions really create an incentive to bring forward a lot in the first submissions, and then the case file gets bloated. And with that, I think I will close my remarks, and thank you very much for your attention. Thank you.
Thank you. Thank you, Tanya, for your perfect report, for this interesting insights about Swiss procedure. We will discuss in the next part of our panel, but only one remark maybe, because the Swiss so it's remark only, because the Swiss regulation, the Swiss Code of Civil Procedure of 2010 is treated in Poland as a very good example for the new regulations, because it's not so detailed regulation. It was, because it's something about 400 articles, it's a perfect open code that you may fulfill this code with practice. But as we see now, this is a great change, yeah, because it's much more formalistic in these amendments from 2015, yeah, because this open code was not appropriate for lawyers maybe, or for attitude of lawyers from different cantons. But we will discuss, I think, later about these issues. Okay, and now we move to Italy. I invite Michele Angelo Lupoi, a professor from University of Bologna, who will present us the Italian perspective for the concentration of facts and evidence in the historical and the future. We will see how it looks like in Italy, because I know that Italy has the same problems as Poland. We've got many cases, which the duration of these cases is very long, so this model of concentration is a crucial for streamlining of proceedings. Michele, the floor is yours.
Thank you. I will skip the thank you phase, but I thank everybody for being here, especially Andrei for his endurance in organizing this conference and bringing us all together. Yes, the Italian perspective is, I guess, rather similar to that of other countries, with some peculiarities. Okay, let's face the elephant in the room. Our proceedings last for a longish period of time. So for the past 35 years, we've been struggling with attempts at reducing the duration of the proceedings and trying to make them more concentrated. Actually, the Italian father of civil procedure, if we want to talk about history, Giuseppe Chiovenda, his idea was that the most efficient civil proceedings should be oral, concentrated, and immediate. Now we are dealing with with concentration. Everybody loves concentration in theory. The parties, because it's their case is dealt more swiftly. In the parties, and as a lawyer, I would say, in the client's mind, you enter the courtroom on day one as a claimant, and you exit the court on that very same day as a winner. And it doesn't work like that, of course. Lawyers also should love concentration, because there is nothing worse as a lawyer than studying and preparing a case today and then having to discuss it to have it decided 3 years afterwards. It's like a completely new case, and the case law may have changed. You were a winner 3 years ago, and you are a loser now, at least in Italy. I don't know in other countries, but the case law is always evolving. And also judges, of course, they should have a more immediate impact with this case. And then, of course, concentration has a lot of obstacles, and we've heard from the Switzerland experience. Lawyers love to be able to change their case, to amend. Somebody was talking about military plans. The best laid plan fail at the first contact with the enemy. You may conceive the best plan, and then as soon as you face your opponent something that you have not thought about, comes into the picture. So lawyers like to try and bring new facts, new defenses, sometimes new claims, and most often new evidence. And this, of course, is an enemy to concentration, but it is a friend of justice, in a way. And at least in Italy, concentration also has to deal with the fact that the judges simply cannot afford to hold hearings close to each other in the same case. Now, my academic mentor, Professor Federico Carpi, always told me, when you are in an international event, there is no need to talk badly about your country, and he's right. I mean, Italians have it, we like to fustigate ourselves, which sometimes it's not the case. We do better than we think. But he was online the other day, one justice of the peace in a country, in a small town in Italy, basically postponed a case which judge himself considered easy from 2025 to 2031. So it's 6 years to decide an easy case. And that's not concentrated in my mind. And this is something that no rule of procedure can tackle. You need investments in the courts, you need judges, you need law clerks, you need IT systems to deal efficiently with the new reality of IT proceedings. Now let's go back to the Italian situation. As I was saying, we've been struggling with trying to make proceedings more fast by making them concentrated, basically basing our reforms in the last 35 years on preclusions, procedural preclusion, deadlines, fixed time limits to perform the activities. This started in 1990 with a system based on several hearings and several deadlines between one hearing and the next. And it was a rather slow process of creating the scope of the proceedings and the scope of the evidence. It took some months, sometimes some years before, closing the files, as we have heard from the Swiss experience. That system is no longer in place. It has been revised several times, most notably in 2022. But before going into some aspects of Italian civil procedure, I think that two elements must be considered in order to understand our position. The first aspect is a legal aspect. We have a provision in the Constitution, Article 111, which basically says that the judicial function is implemented through due process regulated by law. So we have a provision in the Constitution which says that civil proceedings are regulated by the law, not by the courts, not by the judges. Basically, proceedings which are not analytically and in a very detailed way governed by law are unconstitutional, in theory. In practice, we have especially provisional remedies which are very unregulated by law. But then no res judicata arises, so they are accepted. But if res judicata is at stake, there are some authoritative voice of the Italian doctrine. They say proceedings which are not strictly regulated by law are unconstitutional. So this is the first. And connected to this legal aspect is a meta-legal aspect, which is a general suspicion towards judicial discretion. In Italy, I guess also elsewhere. We have historical reasons, I will not go into that now, but basically the Italian lawmaker tries not to give too much discretion to judges to govern the proceedings, also because there is this constitutional framework which needs to be taken into consideration. So these two aspects are important. You have to keep them in mind to understand what happens in our country, like in other countries, I guess. And something which happens in Italy, and it's, I guess, the same in all of the civil law countries, is that we don't have a pre-trial phase. Common law proceedings have they say, oh, they last 2 or 3 days, concentrated hearings. Yes, because they go to court after years of pre-trial, and sometimes they never go to court because of years of expensive pre-trial discovery and disclosure. We don't have pre-trial disclosure or discovery. Today we have mediation. Sometimes mediation is mandatory in Italy. During mediation, sometimes you get to know the cards of the other party. And sometimes you discover that it is better just to sit down and relax and not go to court at all, which is also important. But most often, civil proceedings start when the parties are not aware of the other party's evidence and defenses. And of course, this can lead to very bad surprises, because most often your client does not tell you everything, and But this element of surprise is an enemy, an obstacle to concentration. Because of course you have to have steps where you bring facts and evidence, and you have you need time to react to the other party evidence. So these are obvious considerations. But with these obvious considerations, since 1990, that's the reform I was telling you about, which introduced this system of preclusion, we have been dealing with it, trying to concentrate the activities in shorter amount of time. The latest reform is from 2022. If you are into Italian things, you might have heard about it as the Riforma Cartabia. Cartabia is the name of the then Minister of Justice, which promoted this reform. And now some lawyers are, we were discussing with Andrea yesterday about the bar elections in Poland. Now there are bar elections in Rome, and one of the lists is called Aboliamo la Cartabia, meaning let's abolish Cartabia. Of course, not the minister, but the reform. And now our things have changed a lot in theory. Basically, the first hearing, so the first direct contact between the judge and the lawyers happen after the parties have exchanged several memorandums, 4. So there is the original claim, then the statement of the defense. After the statement of the defense, the judge comes into the scene, but not through a hearing, through an order, which is given without meeting the parties, which is problematic. And I will get back to this later. So we receive this order, and this order may, for example, postpone the hearing. And from the date of the hearing, you have 3 peremptory deadlines to complete the allegation of fact and the allegation of evidence. Very tight deadlines, basically 40, 20, and 10 days to react to each other's defenses and evidence. In family proceedings, this is even worse, because the framework is the same, but the deadlines are tighter. 20, 10, 5 days before the hearings. And I'm a family lawyer, mostly, and I can tell you that we do work a lot in very concentrated period of time. And this can be very difficult, especially because I don't want to go into too many details, but under Italian law, when a certain deadline runs backwards, and it falls on a festive day or a Sunday, you go back. So if you have 5 days and the 5th day is a Sunday, you go back to Saturday. But Saturdays, God bless, are treated as Sunday. So you go back to Friday. And if Friday is a national holiday, you go back to Thursday. So instead of having 5 days to defend yourself, you can have 2 or 3. And when this implies reacting to the other party's new evidence, I can tell you it's a problem. It is a problem. And actually, this is right now before the Constitutional Court. So concentration is a very nice thing in theory, but when you are a lawyer and you have 2 days to, respond to 30 documents from the other party, that's, especially because when this deadline elapses, the theory, and not the theory, the reality is that no new facts are allowed, no new evidence is allowed, and basically you're stuck with what you've done in the first few weeks for the rest of the case. The rest of the case can last 10 years. It has happened. all the way to the Supreme Court, of course. At the appeal level, we have a very tight rule. It has been tightened since 1990. Basically, no new claims, no new defenses, no new evidence, unless evidence which has been created lately. So now, as lawyers, we know, we are aware that what you do in the initial part of the proceedings is basically unchangeable. And sometimes this leads to problems. Of course, there are exceptions. Of course, if the judge decides on factual considerations which were not considered by the parties, then you can have the opportunity to react at the appeal level. But, you walk uphill when that is the case. So this is in theory, the situation now. When we appear before the judge at the first hearing, the cards are on the table, and basically the judge is in the position to admit the evidence, open the evidentiary phase, and decide the proceedings. So these are new rules. It's difficult to say if they are working. I can tell you, in family proceedings, they have changed the reality a lot. Family proceedings now are much shorter than they were, so this is good news for the European Union. I guess the European Commission is happy with that. But the game changer was the introduction that in family proceedings, the introduction of what we call patrimonial disclosure. Basically, the parties are required to file with their original claim or with their defense their bank statements for the final 3 years, which was not requested until 2022. And so when we appear before the family law judge, every party knows what the other party has officially in the bank and what that party spends if some undetected money arrive on the bank account. And that has changed a lot, and many cases are decided with a mediation, with an agreement at the first hearing. So sometimes if you work on the rules, you can get to an effective result. But that's the specificities of family law, probably. So, I've written and I've said in other occasions that in 2022, with the Riforma Cartabia, the Italian lawmaker lost an historical occasion, at least from my perspective, to introduce a system of real case management. To implement flexibility, proportionality, concentration, getting away from the system of preclusion, which is an enemy of real justice. We haven't done that. Probably the lawmaker was too much under the pressure of, you know, the European Union wanting action, so they couldn't spend years discussing about systematic ideas. So now the situation is a little bit of a compromise, the Italian compromise. We're very good at that. So no case management as such. We don't have the main hearing like in other systems. But we have this switch between an ordinary proceedings, which works the way I tried to, you know, sketch out a moment before, and what we call a simplified procedure with less hearings and less written memorandum. And the switch from one course of the proceeding to the next can be done on the claimant choice at the beginning of the proceedings, but then the judge may decide that the case should go in another direction, or directly by the judge in the order which the judge files after the statement of the defense of the claimant. So today, basically, every ordinary proceedings may turn into simplified proceedings, and every simplified proceeding can turn into ordinary proceedings. I will not go into the details. Let's not just say it's not case management. Most of the time, it's just dealing with the reality of not being able to simplify proceedings because there is no time to do things fast. So, but that, you know, reality and theory are sometimes enemy. I will not go into more details because time is running out, and I prefer to give some ideas on how to feel civil procedure in Italy right now. There are a lot of good instruments, like what we call calendario del processo, the calendar of the trial. Basically, at the first hearing, the judge should set the dates of all the subsequent hearings until the end of the proceedings. In practice, this is very rarely used for many different reasons. So another difference between theory and reality. So what do we have now? We have very rigid models of proceedings, very tight deadlines, not a lot of collaboration between judges and lawyers, certainly very little, if at all, collaboration among lawyers. Sometimes the judges require lawyers to write together the report for the hearing. And that's where you see all things of fireworks going on. So, and within this system, you have two things to consider. First, the Supreme Court, since 2015, has totally changed its approach to the amendment of the original claim. Until 2015, we had a rather formalistic idea of what a claim is, the object, the title, the parties, and especially the title was made of the specific facts from which a certain right arises. In the German tradition, very formalistic, but I mean, we've been teaching our students that if you change the facts, you change the claim, and because you change the right. And all of a sudden in 2015, the Supreme Court comes out with this idea, well, as long as you remain within the same factual situation, the same legal relationship, you can amend your claim in the first step of the proceedings, of course, by bringing new facts, new claims. For example, the idea that if you deal with a contract and you initially apply for that contract to be null and void, Then during the proceedings you can say, oh, but there is an unjust enrichment. Until 2015 these claims were different. You couldn't bring unjust enrichment when proceedings had started. Now you can. And of course, this impacts with the system which very tight deadlines. And after the first claim, the first written memorandum, you find new claims, and you have 20 days to respond to that. 10 days in family proceeding. That's a surprise. In family proceedings now, you can bring as a counterclaim divorce in a petition for separation. In Italy, we still have separation and divorce. We are, I don't know, in Poland, maybe we have the same tradition. So now you bring your claim as separation, and it transforms into divorce, and you have 10 days to reply to the new claim. Unsurprisingly, the Constitutional Court has already been called into action. There is already one decision dealing with this new introductory phase in the ordinary proceeding, and basically the Constitutional Court says if the need arises, the judge is free to set hearing to discuss preliminary issues. So basically concentration has gone down the drain by constitutional decree, and it makes sense. And now there is a case under examination of the Constitutional Court about family proceedings. One court of first instance said the deadlines to reply to the other party's new claims is too short. This prevents an effective right of the defense, and we are waiting for that. If the Constitutional Court says that this complies with the constitutional right of the defense, I would be surprised. But I don't know how the Constitutional Court will intervene without destroying the whole reform of 2022. We will see. For now, we wait. Thank you very much.
Thank you, Michele, for your presentation, and I think that both reports underlined the role of the practice in this topic, because we may look at the codes and look at the regulations which are really perfect, but the real question is how does it work in practice? What is the attitude of the Corte di Cassazione or Federal Tribunal in Switzerland to explain these notions in the code, and what is the practice of lawyers in these cases? Because concentrations of facts is in reality the practice of working, not only articles in books. So I think that it will be a great element of our discussion. Move to our next reporter, who will contact with us remotely, Professor Fernando Gascon-Inhausti from Complutense University of Madrid. Fernando, do you hear us? Oh, we see you. Hello, Fernando.
Not yet.
Yes, now we are hearing you. Fernando,
you're
it's
hearing
perfect.
me now.
Now it's okay.
Okay.
Okay,
Well,
so once again, it's a great pleasure
and you're
to
hearing
host
me?
you.
Sorry, Piotr. Are you hearing me again?
Yes, we are
Okay,
hearing
so
you now.
it's my computer now.
Yes, now it's okay, Fernando. So we may move to your report. Thank you for your presence here from your linking with us from Madrid. So the floor is yours. We are hearing you. You may start.
Yes. Well, dear friends, thanks so much to the organization, and especially for Andrei, who, as Stania said before, very diligently organized everything. I believe him and many other people in his team, I can imagine. Thanks to everyone. And of course, first of all, also I want to apologize because, well, family issues, life is not easy these days, have prevented me from traveling to Krakow, as was my wish since many months ago when we started to design this conference. It's a pity because so much effort, and I can finally not join you there. But nevertheless, I'm happy to see some good friends, even in the distance, and I've enjoyed very much the first presentations. I will share with you my screen. I believe this is also possible. Are you watching now?
Yes, it's good. You may full screen even. Oh, yeah.
Okay, and now I'm not full screen, but I will be full screen again. Just trying to make sure that everything was working. So, well, let's go to the point, because I know that the schedule is tight and these technical issues already stole some time from us. Well, as the persons that have presented before me, we're talking about past, present, and future. So I believe, because, well, Poland is quite away from Spain, also from the point of view of the legal culture, I believe it's convenient to make a first presentation of the Spanish civil justice system in order to provide the right framework to focus then on the main issue, which is concentration of facts and evidence. So first main idea, well, we reformulated completely our civil justice 25 years ago. So we had been dealing with a very old-fashioned code of civil procedure from the 19th century, but in fact it was a Middle Ages law, just written in a 19th century language. And the system at the edge of the millennium was not functional at all. Civil proceedings were mostly written. Well, the judge was formally there, but in fact, the judge was only present when the whole file had been developed and just ready to write the judgment. And of course, delays were unacceptable. The most common critique beyond deadlines was that many times, just by reading the file, the judge was not had not been able to understand really what the case was about, and this was the main issue, the main ground for lack of satisfaction of legal practitioners with the system. The new code changed everything. It entered into force 24 years ago. Of course, it's been amended many times, as what was as usual with modern legislation. But this is very important for the purposes of today's conference. The main goal, all the effort was put into reinforcing the value of the first instance. This is all what the project and the new code was about. The idea was I like to use this sentence. It was to place the judge in the best position to give the best judgment. So the code combines written proceedings and oral proceedings, or written activity and oral activity, with a special emphasis on concentration and on immediacy. I will come back to this later on. But it's also important to assume that, well, we're a very populous country. People have trust in justice, so they tend to go to court when they are not able to solve their disputes by themselves. So the system is prepared to deal with a huge amount of cases. So it cannot be, as the English say, Rolls-Royce justice or tailor-made justice. It's middle-class justice. It's one size fits all. This means that our proceedings are not flexible at all. They're quite rigid, because only rigidity allows mass case management. And of course, this means that this idea, also this English idea of personalized case management, and just by the dates, you can see that our reform came parallel as the English one. Well, this typical English personal case management is completely absent from our system. Our system believes in treating all the cases the same way, so we can process many cases at the same time. This is the focus. You have to know this, because otherwise you won't understand how it works. More detail, more information. Well, in Spain, we have many, many lawyers, much more lawyers than judges, indeed. So the system is designed to be a lawyer's procedure. This means that lawyers are mandatory if the value of the case is above 2,000 euros. So in practice, all civil cases are cases with lawyer. Even smaller cases, which are quite rare, in practice, parties tend to use these lawyers.
Fernando, sorry for interrupt, but the slides don't change. I think that maybe you should minimize. Oh, now is okay. Okay.
Okay, well then I will use the small slide,
okay.
and that's the point. Thanks, Andre, for that. I apologize once again to the audience because of these small technical problems which are always disruptive. Sorry for that. Well, important idea. We have lawyers. Lawyers are everywhere. But this also means that procedural requirements and standards may be higher because people expected to comply with the law are not just citizens, but are or should be qualified lawyers. Second idea, we have a very strict way to understand the principle of party disposition and of judicial impartiality. So the powers of the judges in Spain to act ex officio, to raise issues ex officio is very limited. Judges are not allowed to introduce facts by themselves, logical. Judges are not allowed to introduce legal grounds, potentially applying to the facts by themselves. This is not so common. This is something which is not always like that in every jurisdiction. And of course, this is also something which is not the same everywhere. Judges are not allowed to order ex officio the taking of evidence, not even the taking of expert evidence, which is different to the situation in other jurisdictions. Why? Well, because we have a very strict vision of judicial impartiality, and well, we believe that a judge raising ex officio a legal ground or a judge ordering ex officio the taking of evidence could be regarded as supporting the position of one of the parties into the detriment of the other, even if when doing so, the judge does not know whom he would be helping. But this is our vision. Michele said at the beginning of his presentation, we should not talk badly about our own legal systems. I am not talking badly about mine. I'm just describing it. I'm just sharing with you how strict it is. And this has been always like that. So it is not a controversial issue. Lawyers are accustomed to it, as well as they are accustomed, as I told before, with preclusion and procedural rigidity. So the margins for the parties to negotiate among themselves and with the court, procedural deadlines, procedural acts, and so on, is practically inexistent. Procedure is strictly established by the law. Deadlines are strictly established by the law. Lawyers have to abide with it. Judges tend to be inflexible, except for, of course, justified and legally established reasons. And this also means that preclusion operates as the main trigger for complying with procedural legality. So preclusion is very strict. Deadlines kill the possibility of doing afterwards what should have been done earlier. And as I will explain very shortly, preclusion is also the instrument we use to enforce the rules on concentration of facts and of evidence. Another necessary framework information: how are first instance proceedings in Spain designed? Well, I believe following this Austrian model, Franz Klein, the German model, we have a first phase, written phase, where parties exchange statements of claim and of defense, but only once. So there will be only one statement of claim, and after that, only one statement of defense. and the claimant will not be able to respond in writing to the defense, and the defendant will not be able to respond in writing to the defense of the claimant against the defense. So only one shot. This is very important. Differently to what happens in Italy or to what happens in France, there is not an exchange of statements until arguments are exhausted. The claimant has to put all his artillery, all his arguments, all his reasons in the statement of claim. And the defendant has to present all the defenses, procedural ones, affirmative defenses as well, in the statement of defense. What's not included there will be precluded. This is, of course, a very strict provision, a very strict rule, but it's the only way to handle with many cases at the same time. After that, there will be a preliminary hearing. Orality starts here. At that hearing, parties will try to close the scope of proceedings. They will establish which facts are considered admitted by both of them and which facts are considered controversial. And on the basis of the definition of the controversial facts, the parties will have to propose the evidence they intend to use, and the judge will rule on the admission of evidence. At that point, the preliminary hearing ends and the parties will be summoned to attend later on to the main hearing. At the main hearing, evidence will be taken, and the lawyers will be able to make some oral conclusions, yes, making a resume of what has happened so far. Just for your information, because it's not as important as it should be for what comes afterwards, but it's a very recent twist, starting this last month. Parties are required to undergo adequate dispute resolution mechanisms as a procedural requirement before going into court. As I said, well, this is not something that has to deal with the scope of proceedings or with the idea of concentration of facts and evidence, but it's just a recent feature of Spanish procedural law, this idea that we have to try mediation or conciliation or expert determination before being able to go to court with a dispute. And now, let's start with concentration of facts. There's a general rule, and I shortly described it. Everything must be inside the statement of claim. Not only facts, but more broadly, causes of action able to sustain a claim. Everything has to be there. Of course, if the same facts can be regarded from a legal perspective differently, and because there are potential different legal qualifications for the fact, the claimant has the possibility of making a subsidiary joinder of legal grounds in the claim. But all of them have to be there. This is something established by a very interesting rule, which is Article 400 of the Spanish Code of Civil Procedure. To those of you familiarized with French procedural law, there was later on a decision of the Cour de Cassation in the Cesáreo affair. Well, our provision is Cesáreo avant la lettre. I will share with you very shortly, just for you to understand it, because this rule applies not only for claimants, but also for defendants. And it states as such, it's, my unofficial translation, but where a claim may be based on different facts or on different legal grounds, all of them, as they are known at the time you start with the case, shall be stated inside the claim. And it's not possible to reserve the submission of those facts or legal grounds for a later proceeding. Of course, you may adduce new facts later on, but only if they are really new. Not if you would have been in the position to adduce them into your claim from the very beginning. So this is the rule. And in number 2 are the consequences. And the consequences deal with lis pendens and res judicata. So if you start a legal procedure afterwards using different facts or different legal grounds you could have presented in the first case, this second case will be barred by lis pendens, even if the scopes of both proceedings are not the same because facts or legal grounds have changed. But the fact that you could have used them in the first case entail the consequence that the second case will not be able to proceed. And of course, if the first case has already finished with a final decision and you try to start a new case adducing different facts and different legal grounds, but you were in the position to have adduced them in the first case, then this second claim will be barred by, well, res judicata, says the law. I would say it's rather preclusion because these facts and legal grounds were not strictly speaking judged in the first case, but this is the instrument we use to exclude the possibility of using them subsequently. So you see the consequences of this strict rule of concentration of facts is that afterwards you cannot change your statement of claim, you cannot start a new proceeding in parallel to the one you started, you cannot start a subsequent proceeding with the same scope, being the scope the same, even if facts and legal grounds are different, if these facts and or legal grounds could have been used in the first one. I would say this is rather strict, but I would say this is not so controversial in practice. And when I say in practice, I say judges and I say lawyers. We are accustomed to it. We are not reluctant to it. So differently to what Michele said, we do not want to abolish our Cartabia because in fact, this is not a Cartabia or this is not an imposed reform to change legal tradition. This is the way things have been for many time. Are we able to invoke new facts during the course of proceedings? Yes, of course. During the first instance, this is Article 286 that allows you to present new facts or to present new evidence any moment, but under a very strict burden to show that the fact is new or that the fact is really newly known, even if it was previous. Otherwise, the fact will not be accepted into the proceedings. And if you are deemed to have tried to be that, to do that in a dilatory manner, then you may also receive a fine from the court. So yes, new facts or newly known facts, you can present them until the very last minute of proceedings, but only after strictly overcoming the burden of showing that they are new or that you couldn't be able to know them so far. This rule in practice is used and it has not been really controversial. Of course, it's controversial in a case if the parties litigate on the idea of the facts were really known or not. But the rule as such is specifically accepted. We can, of course, introduce new facts or newly known facts during the first appeal. And we cannot do it during the appeal for cassation because our appeal for cassation is referred only to legal aspects, none to factual aspects, as well everywhere in continental legal culture. So this is not strange to you, and I won't bore you with that because I believe at that point the possibility of adducing new facts during the first appeal and not adducing them in the appeal for cassation is common ground for all our legal systems. Evidence, I would say, we have to make a distinction on concentration regarding the proposal of evidence and regarding the taking of evidence, if you admit this rather academic distinction. So when it comes to the proposal of evidence, which I believe is the crux of the matter here, our legal system makes a clear distinction between tangible evidence, I would say, so pre-existing means of proof, and personal evidence. Why is this distinction important? Because all tangible evidence, basically documents and electronically stored evidence, needs necessarily to be presented together with the claim or with the statement of claim. So all the package, all the tangible package goes with the claim. So all facts and all tangible evidence is shown by the claimant from the very beginning. And of course, the same applies to the defendant in the statement of defense. Everybody goes in the same package. So from the very beginning, each one knows the ammunition of the counterparty. What happens with personal evidence? Parties do not need to refer to them in their statements of claim or defense, even if they can do it. It's a matter for the preliminary hearing. So at the preliminary hearing, the parties have to insist in the court admitting the tangible evidence they presented at the beginning, and they have to propose the list of witnesses. They may propose that the expert that drafted the expert report goes to the hearing and is cross-examined, and of course also the cross-examination of the counterparty. With all that deals with personal evidence needs to be proposed directly at the preliminary hearing. Why? Because it's only there, once the scope of proceedings has been closed and once the list of admitted facts and controversial facts is made, that the parties are in a position to decide on which tangible evidence already presented they want to rely and what personal evidence they want to propose. So this is the idea. So the meaning of concentration is the following. Tangible evidence, documents, shortly, need to be presented from the very beginning. You can only present them later on if they are new or newly known, exactly as with facts. Personal evidence does not need to be relied on or upon from the very beginning. You can just do it at the preliminary hearing. Can you propose the taking of evidence during the first appeal? Yes, and I believe this is common ground. If it's new evidence, or if it's evidence that is newly known, or if it's evident you proposed to be taken in the first instance, but could not be taken for grounds that are not attributable to the party that made that proposal. Once again, I would say common rules, common ground in our legal systems. Can you propose evidence during the appeal for cassation? And the answer, of course, is no. Cassation is only for legal issues. Facts are considered as established in the second instance judgment, common ground. As far as the taking of evidence is concerned, well, this is one of the main changes of the system in the year 2000. The taking of evidence is concentrated during the main hearing. So all evidence, all personal evidence will be taken together one morning, 2 hours, 3 weeks, depending on the volume of the case, but in a concentrated manner with a judge that needs to be present. So also the idea of immediacy. So the taking of evidence is not scattered. It's not that today I hear that witness, in a couple of weeks another one. No, it's all concentrated for the sake of this idea of placing the judge in the best position to make the best judgment. And we believe that if you take evidence not in a concentrated manner, there is the risk that more fresh evidence or more recently taken evidence gains more weight than the evidence that was taken a longer time ago. And of course, but this is once again common ground, we can anticipate the taking of evidence. For instance, if the witness is about to die or about to travel to a country where he will not have an internet connection to be examined by video conference. We can also have a belated taking of evidence, so evidence that could not be taken during the hearing for unexpected reasons can be taken at a later moment before judgment is passed. And of course, it can also be taken during the first appeal in the cases where evidence is admissible for the first appeal. And this is all. I will stop sharing my screen, but I thank you very much for your attention.
Thank you, Fernando, for this perfect presentation about Spanish attitude to the concentration of facts. As we saw, this is quite different way than it was in the previous systems. This is the preclusion system, and it concerns not only facts and evidence, but even the legal qualification or what is called in French cause from the Motulski papers. So now we may move to the French regulation. I invite Dr. Etienne Nedeyek de l'Université de Panthéon-Sorbonne, who will present the French perspective for concentration of facts and evidence. Please, the floor is yours.
Okay, thank you. First of all, I would like to thank the Jagiellonian University in Krakow for its warm welcome and for this initiative. And I must also, as my colleagues, express my sincere thanks to Andrei for this outstanding and enthusiastic also organization of this event. The French situation may seem somewhat disappointing to you. We do not have any doctrine or rule of factual or evidentiary concentration. If one searches through our procedural history, it is in fact quite difficult to find even a single mention of the notion of concentration. Actually, it is only with the Cesario judgment that Fernando quote, handed down by the Cour de Cassation on the 7th of July 2006, that the term concentration entered French procedural debate. And I can already indicate that the form of concentration at stake since then, since the Cesario case, has been legal concentration, not factual concentration. And in France, contrary to Italy maybe, everybody hates concentration. Really, there is no love for concentration in France. We did not have our Chiovenda, and if we found someone that could play that role, it did not promote concentration nor orality. From a historical perspective, then, the past of concentration is essentially an absent past, or at least one that unfolded under a different name. In our recent history, we can identify three situations in which the idea of concentration, if not the term itself, is present, at least broadly speaking. The first one is the broadest one, and to a point where it seems almost inappropriate for us to talk about concentration. It's the traditional rule that the mere circumstance that a fact was not debated in a previous trial does not always suffice to override the authority of res judicata. Is the distinction between newly discovered and newly arisen facts. Also, on the evidential perspective, the authority of res judicata stands as an obstacle to any attempt to bring a new action solely on the grounds that new evidence has been obtained. There is no possibility to make another trial on new evidence, except regarding to fraud and revision, but it's not the principle. The second example, historical example of concentration is the classical rule of concentration of the procedural defenses. It illustrates the traditional conception of French civil procedure as a system of formal requirements serving substantive justice. Procedural objections must be raised. Simultaneously, we could say there is a concentration of procedural defenses, procedural exception, but it's not much. And the underlying logic is relatively straightforward. If a procedural irregularity is not raised at the outset and the parties begin to argue on the merits, then the defect is deemed insufficient to prevent the case from proceeding forward. So it's nothing much, but it could be said a concentration. Beyond this, very little can be found in our legal history regarding concentration, though we can find a third situation that has been abandoned with the Code of 1975, but I think might interest some of you here. It's the immutability of the subject matter of the litigation. In France, immutability has meant something relatively straightforward. Once proceedings have been initiated, their elements, their framework, are not to be altered. The prohibition meant that the subject matter could not be modified. No new claims could be introduced, no shift in the function or structure of the civil trial permitted. Nothing particularly surprising here. The goal was to ensure that a party could not, midway through proceedings, change the substance of the case, thereby diverting the central question and delaying the resolution of the original dispute. It is a long-standing tradition aimed at excluding irrelevant issues or attempts to introduce a new dispute into proceedings that were already close to resolution. Thus, the prohibition concerned the introduction of certain facts, but only insofar as those facts were not constitutive of the original legal claim. In other words, when new facts entailed a new legal claim in themselves, they could not be introduced into the ongoing case. A new action had to be initiated elsewhere. The prohibition was not so much about factual concentration per se, as you understand, but about the immutability of the claim, of the first claim. But from the early 20th century onwards, however, this principle was gradually called into question, to the point that it is considered today largely obsolete. Why? Because it is now accepted in France that both the petitum and the causa petendi of the dispute may evolve. The object and the cause of the subject matter and the factual grounds of the dispute may evolve. This is expressly stated in Article 4 of our new, from 1975, Code of Civil Procedure, that states that the subject matter of the dispute is determined by the parties' respective claims. These claims are set out in the originating writ and the statements of defense. However, the subject matter of the dispute may be modified by incidental claims, provided that they are sufficiently connected to the original claims. But you might ask, what does this have to do with concentration of facts? In fact, the connection is quite strong. The philosophy of our civil proceedings today is one of resolving the conflict between the parties as fully and completely as possible. The only limitation is that any new claim must be sufficiently connected to the original claims, so as to guard against any dilatory maneuvers by the opposing party. If we turn to the language of the drafters of the 1975 Code, Cornu, Foyer, and Motulski of Polish origins, the aim was to place civil procedure in the service of the ascertainment of truth and the application of objective substantive law. And to achieve this, it was necessary to grant both the parties and the judge greater means of contributing to the effective establishment of the facts, without closing the door to the evolving nature of the case as shaped by the exchanges of written submissions and arguments. This is the key of French procedural system today. From this, it was concluded that the principle of immutability was way too rigid and stood in the way of the proper administration of justice.
In practice, this philosophy is reflected in Article 6 through 10 of the Code of Civil Procedure. The first three deal with facts. Article 6, I quote, "To support their claims, the party must set out the facts on which those claims are based." Article 7, "The judge may not base a decision on facts that have not been debated in the proceedings, but amongst the facts discussed, the judge may consider those not specifically relied upon by the parties in support of their claims." So there is an initiative of the judge within the factual debate. The judge can investigate on his own. And Article 8, the judge may invite the parties to provide any factual explanations he or she deems necessary for the resolution of the dispute. The next two articles, 9 and 10, concern evidence, and I will finish reading. Each party must, in accordance with the law, prove the facts necessary to support their claim. But Article 10, the judge may, on his or her initiative, order any legally admissible investigative measures. Moreover, within this broader movement of strengthening judicial powers, one particularly important point for our topic must be highlighted. Much of the theoretical effort was aimed at reducing the scope of the dispositive principle. Too deeply rooted in the liberal tradition, this principle was denounced as an obvious factor contributing to the exacerbation of inequalities already present in substantive law, and it was also seen, as Klein stated, as one of the most certain ways to arrive at a resolution that failed to meet the requirements of objective law. To counterbalance what appeared to be a weakening of the position of the party, at least as this had been classically idealized by the liberal model, the principe du contradictoire, the right to be heard, or principle of adversarial proceedings, was considerably reinforced. Ubiquitous in the new Code of Civil Procedure, it underpins the notion that truth is reached through the exchange of arguments and responses to each and every element of the case, even to those raised ex officio by the judge, which is the possibility and the major innovation since 1975. It is within this intellectual framework that we must situate the current approach to concentration of facts and evidence in France. The aim is not to concentrate, but to fully resolve the dispute in one trial, one long trial maybe, first degree and appeal included. As I briefly mentioned earlier, the Article 4 of our Code of Civil Procedure expressly allows for the evolution of the dispute, as the submissions and incidental claims of the parties unfold. Even appeals today allow for a small evolution of the subject matter of the dispute. We still speak of appel voie d'achèvement, an appeal as a means of completing the trial, rather than a simple appel réformation, which would focus solely on overturning or modifying the first instance judgment. Even though it should be noted that many people are battling to change from the first to the second conception of appeal today in France, it's still standing. In line with the appel voie d'achèvement, an appeal as a means of completing the trial, Article 563 today, for example, provides, in order to justify on appeal the claims they had submitted to the first judge, the parties may rely on new arguments, produce new documents, or propose new evidence. This provision encapsulates much of the philosophy underlying French civil procedure. The aim is to resolve the conflict as comprehensively as possible, so that parties do not return to court with the same or closely related facts seeking a second decision. In practice, this ambition is most clearly reflected in the mise en état, which is the pre-trial phase that has been adopted in France. In ordinary proceedings today, French ordinary proceedings, the mise en état, the pre-trial phase, constitutes the standard phase of instruction of the case. To determine the appropriate procedural pathway, the Code provides for the holding of an initial hearing. During this hearing, the presiding judge unilaterally determines the appropriate procedural track for the case. That is, the degree of instruction and case management that will be required. In theory, there are 4 procedural pathways, but depending on the complexity and the expected duration of the instruction. In practice, however, the so-called short tracks are never used. For instance, in the Tribunal Judiciaire de Paris, French first court, there is a mandatory mise en état today. Everyone goes through the pretrial phase. What's in the pretrial phase? It's actually the main topic for tomorrow's French reform. It's the pretrial phase. Theoretically, it's working well. The issue is that today we are expecting the judges, not the parties. Attorneys play their role. It's the judge that is too slow for the French procedural pretrial phase. So in almost every case, as I said, there is a pretrial phase. The juge de la mise en état, the pretrial judge, a judicial figure introduced now almost a century ago in 1935, who has steadily gained greater powers in recent decades, performs a range of functions, notably including the examination of certain preliminary procedural issues before the court addresses the merits of the case. But for our purposes today, his most important role is that of overseeing the factual and evidentiary instruction of the case. He is the judge responsible for preparing the matter to be in a proper state for judgment. He may set a case management timetable, which he establishes with the input, though not the agreement, of the attorneys. This schedule sets out the expected number and the timing of written submissions. Extensions of time may be granted, but only for serious cause. There are then a series of hearings, now held digitally and occasionally in court, during which lawyers file their submissions, supporting documents, and may request investigative measures. The opposing party then responds in turn, and in practice, after 3 such hearings and rounds of exchanges, the case preparation phase usually comes to an end. And this is where we have issues because the parties are ready to go on the merits and the judge does not do anything. So we kind of wait sometimes 1 year or even 2 years for the judge to close the pretrial phase. So it depends on the diligence of the case management judge, who, when he is very diligent, may require the parties to file their final submissions and even issue a partial closure order to sanction a party and prevent it from filing further submissions if the party is too late to produce the requested elements. And the judge may also exercise all powers necessary for the communication, obtaining and production of documents, answering to the request of the parties, or acting ex officio. And because the original conception of the mise en état was that of an intellectual preparation of the case, this judge is considered best placed to adopt a wide range of procedural measures, even ex officio, including investigative measures. So for testimony, for expertise, etc., it's in front of the juge de la mise en état. Our issue is actually here. As I said, we are waiting for more directive, or actually more diligent juge de la mise en état to close and to follow the instruction resulting of the exchanges between the party. Regardless, throughout the mise en état, the parties may produce as many documents and items of evidence as they wish. It's not a question of concentration in France, provided they are properly disclosed to the opposing party and the evidences are clearly listed in their recapitulative submissions, which can also evolve as you begin to understand. So the fact that the law can evolve authorizes an evolution on pieces and evidentiary productions. The only temporal constraint is the closure of the case preparation phase. Once the judge has issued the closure order, ordonnance de clôture, any submissions or exhibits filed thereafter are, as a matter of principle, inadmissible. Yet, even here, even when there is an ordonnance de clôture, closure is not absolute, and further communication may still occur. In principle, any documents or submissions filed belatedly, particularly just before the closure order is issued, are prohibited and indeed inadmissible, as they hinder the possibility of the other party to respond effectively. However, in such cases, the judge may choose not to declare the documents inadmissible, but instead to postpone or revoke the closure order. This allows for last-minute submissions to be debated and ensures that the other party has sufficient time to prepare their response. Once again, you understand, the guiding value here is adversarial fairness, principe du contradictoire, adversarial dispute, rather than concentration. The flip side of the aim of fully resolving the dispute is that we now have a demanding standard of res judicata. Indeed, this is where we find a form of concentration in France, the concentration of legal arguments, achieved through the rule of res judicata. It should be, as Fernando said, much more preclusion, but we do not have this kind of conceptualization in France, so we go through the idea of res judicata to impeach further developments. The Cesario ruling, which I mentioned at the beginning, now requires that parties raise in the first trial all legal grounds that could support their claims. A second action, even if based on a different legal rule capable of supporting the same claim, will no longer be admissible if that ground was not raised in the initial proceedings. A new fact can only avoid the exceptio judicata if the party was unaware of it, and this lack of knowledge cannot be attributed to any deficiency in diligence from his or her part. The few other examples of concentration that have emerged since Cesario in 2006 also concern law and claims, not facts or evidence. One such example appears in appellate procedure, where parties must set out all of their claims in their first set of submissions. But again, this does not apply to facts or exhibits and only apply in appeal, after a first procedure where the parties have been able to widely develop the debate, so it's not so much very strict concentration. So the general idea then is that in French procedure, when it comes to facts and evidence, the focus is on enabling a genuine exchange between the parties, an exchange that is supposed to trigger responses. By definition, this means that one must be able to respond with facts as well, and so the very notion of factual concentration is, in effect, inconceivable. This is all the more understandable given that the legal purpose of the litigation may evolve, and when it does, the factual elements that give rise to its legal effects must be able to evolve accordingly. To conclude, I would like to mention the very rare procedures, special procedures, in which factual and evidentiary concentration has been established in France. In my view, these are no more than exceptions that prove the rule. In France, only a very limited number of procedural contexts could be said to involve a genuine concentration of facts and evidence. What they all share is the imposition of a heightened urgency, beyond the general requirement of expediency that governs all civil proceedings. First special procedure are the appeals against decisions of the National Institute of Industrial Property. Well, it's quite technical, but there is a strict requirement of concentration of claims, arguments, and evidence, all of which must be submitted within 3 months by the parties. Any failure to comply results in inadmissibility, which may be raised ex officio by the judge. Here, the code specifies that supporting documents must be filed simultaneously with the submissions. However, 2 important things must be noted. If the appeal seeks reformation rather than annulment, then the requirement of concentration is relaxed. Multiple rounds of submissions, replies, and rejoinders are permitted, which in turn implies new evidence may be introduced. Indeed, even new claims may be formulated. So there is no concentration if you are arguing for reformation rather than annulment. And even in annulment proceeding, the strict requirement of simultaneity may not be absolute. Case law on appeals suggests that a failure to submit documents and arguments, factual arguments, simultaneously does not automatically result in inadmissibility, as long as they are disclosed in sufficient time to allow for adversarial debate. Once again, concentration logic yields to the logic of dispute development. The adversarial principle underpins the notion of timely communication, and it is the principle that ultimately, always in France, prevails, disabling any rigid application of concentration. And I will finish with another special procedure, which is the fixed date procedure, procédure à jour fixe. A particularly notable procedure, one that could in principle have served as a model for a more concentrated form of civil justice, is the fixed day procedure, which exists both at first instance and on appeal. In this procedure, the claimant or appellant must present their complete submissions at the very outset when filing their application with the president of the court or the president of the Court of Appeal. It is important to note that both in first instance and appeal, there are exceptional procedures reserved for situations requiring exceptional speed, urgency, and imminent risk. However, even in this type of situation, this is not a case for pure concentration, even if the spirit of the procedure is to require that everything be presented at the outset. Case law has made it clear that the claimant may respond to the opponent's submissions or raise plea of inadmissibility at any stage of proceedings. The general principle remains that the claimant may not raise new claims or arguments that were not included in the application or in the summons served on the defendant for the fixed date hearing. That said, the Cour de Cassation, while once held that the claimant could not rely on any document not annexed to the initial application, more recent case law allows the claimant to submit documents in response to the opposing party's submissions. The conclusion is clear. Even under conditions of extreme urgency, where extremely rapid communication is possible, there is no concentration of evidence in France. The entire structure, even urgency, remains governed by adversarial principle. In fact, and this may seem paradoxical, but I think it's not, the role of factual and evidentiary concentration is ultimately weaker in these urgent procedures precisely because of their speed. The core objective is not so much concentration as the rapid exchange of materials. What remains central is the adversarial logic at the heart of French civil procedure. It is through the mutual exchange of argument and the opportunity to respond that the case may be fully adjudicated. At least that's what is at the core of a French procedural system, and that's why we cannot in France speak about concentration of facts or evidence. Thank you.
Thank you, Etienne, for your perfect contribution to this panel and presenting this French attitude, as always, very practical attitude to the theoretical problems like concentration of facts and evidence, especially this traditional institution which evolved like the rule of immutabilité de l'objet of dispute in the context of new tasks. And of course, the most important element which adds something to the panorama of these different systems is the obligation of the court to hear and decide the case properly in any moment. And it's important, and this is the main role of the judge, and we should remember about that. Thank you very much. And at the dessert of this panel, we will discuss about the Polish perspective of concentration of facts and proofs, and I invite the host of this event, Professor Andrzej Olaś, thanking him for the perfect organization of this event, to tell us a couple words about the model of concentration of facts and asking if we've got any model or not in Poland. And of course, after this presentation, we will have a discussion about presented reports. So, Andrzej, the floor is yours. Yeah.
Thank you very much. And before I really start with, is that micro? Okay, this one. Okay, thank you. Thank you very much. And before I start, I would like to really express my very deep, heartfelt gratitude for all of you who have contributed to this event, the co-organizers, and all of you who have decided to show up, to contribute. Thank you very, very much. With regards to the contents of my presentation, I've decided to give it the following title. The Polish experiences with the principle of the concentration of facts evidence for me is pretty much a story of ideals, old and bad habits, illusions, and finally the necessary disillusion. I could also give a more metaphorical title, for example, comparing it for a search for a holy grail, or perhaps chasing the white rabbit only to fall down the rabbit hole. But I think that sometimes what is really necessary is a more direct and direct expression of what things look like. But before I proceed to the very merits of my presentation, a few initial remarks I think are necessary, in particular to those of you who don't know that well the Polish history, tradition, and so on, and the current state of affairs. So first of all, the Polish civil procedure is very much diversified. Not only we have this very well known in many jurisdictions distinction between procedure in contentious and non-contentious matters, but on the top of that, within the proceedings in contentious matters, we have a real myriad of so-called separate proceedings or specialized proceedings of different kind and nature. Why I mention this issue? Because first of all, obviously, the proceedings in non-contentious matters involves a lot of inquisitorial powers of the judge, therefore it changes the dynamics completely. But also in some of those specialized procedure, we do have a specific regimes of concentration which differentiate from the ordinary procedure. This is a case of the commercial cases, intellectual property cases, maybe less, but for sure consumer matters and anti-enforcement actions. In particular, in commercial matters, we have this system of rather strict preclusion, heavy front-loading, and so on and so forth. But as a matter of my presentation, I will focus on ordinary procedure, on these general rules, which at least should be a general principle. The second initial remark, which is also quite important, is that the Polish civil procedure consists of two instances. And in that term, we have a full appellate review. Despite of the fact that the Polish civil procedure is considered as more Germanic, belonging to German tradition, in terms of the model of appellate review, it's much more Romanic. So there is this full appellate review based on the notion of appellatio cum beneficio novorum, which leads to a situation in which the concentration is a matter of both instances. For the sake of brevity, I will focus on the first instance only. So this is the time to start the actual part of my presentation. So let's start with the ideals. In terms of the ideals, the Polish doctrine from the very beginning of the modern times, that is the last, let's say, almost 100 years since the codification of the Polish civil procedural law in 1930. It took 12 years since Poland has regained independence in 1980. to unify civil procedure. Before that, we had 3 or even 4 systems inherited from the occupying empires, that is the Russian system, the Prussian, the German, and the Austrian. The Russian was strongly influenced by the French law up until 1864. The Napoleonic French Code of Civil Procedure was in place in some parts of Poland. But the ideals, as I said, the principle of concentration was rather generally accepted and has been recognized and embraced as one of the guiding principles of the civil procedure. Here you can see the front covers of 3 monographs, one pre-war, from pre-war period, authored by Professor Gołąb from this Jagiellonian University, the second one from post-war period, and the third one, a modern one. Each of them really recognizes and embraces the concept of the concentration. Of course, I could go on and on. There are a couple of dozens of publications, papers, scientific papers focusing on this issue, each of which recognizes importance of the principle of concentration as an element necessary to expedite civil procedure, to speed it up, but also to create conditions in which the judge has access to all facts and evidence, therefore is in a position to administer justice not only efficiently but also fairly. When you look at the law in general, these ideals and aspirations has been reflected by general apex hearing structure, so as to use this IJPL language. That is the idea that the procedural expedition and efficiency should be achieved through a single main hearing, implementing principles of orality, immediacy, concentration, and publicity. Of course, all of these fundamental principles are intimately intertwined with the very structure of the procedure. But the main point is that these obligations have been under the former Code of Civil Procedure and still are under the current Code of Civil Procedure, expressed mainly through the obligation of the court, which should prevent undue delays in the proceedings and strive to ensure that the case is resolved at the first hearing, if possible, without prejudice to the clarification of the matter. Sounds good. I think it sounds very good. On the top of that, Article 206 and 1, as added in 2009 as part of a major overhaul, it's even more unequivocal in this regard. It says that the hearing, I mean the main hearing, yes, the Hauptverhandlung, so as to use the German term, should be prepared in such a way that there are no obstacles to resolving the case at the first session scheduled for it. More than one session is scheduled only when necessary, especially when taking all evidence at one session is impossible. Great idea. Sounds good, I think. And finally, in such case, the sessions should take place on consecutive days, and if this is not possible, in such a way that the time lapse between consecutive sessions is not excessive. So yes, these are ideals, these are aspirations of the Polish civil procedure for a very, very long time. What is the realities, though? The realities is indeed a non-apex hearing structure, a piecemeal, deconcentrated proceedings. Why? Because even in relatively simple cases, unless they are really extremely straightforward, the cases are really rarely resolved upon the first session scheduled for a main hearing. And guess what? If there is a need for adjournment, the next sessions very rarely happen on a back-to-back basis. There is rather a long interval between court sessions. It may be months, half a year, sometimes year, and even much more. For example, when there is a need for an expert evidence to be taken. So these are the realities on the ground, and these realities are quite difficult, so as to say. But what is the but? Even if there is a really long interval between sessions set for a main hearing, legally they are still considered as one single uniform main hearing. Is that serious? I don't think so. But theoretically, we perceive all of this scattered around sessions, court sessions, this May-rain taking of evidence as a one uniform single main hearing. Is this early concentration? I don't think so. What was the root cause? What was the recipe for such a failure? Of course, there is not one such reason. But first of all, as I already mentioned, old habits are hard to kill. And in particular, bad habits are hard to kill. In this particular instance, I would like to quote, it's not a direct quote, it's rather but it's precise. Professor Gołąb from this university in his pre-war work, so this was under the former Code of Civil Procedure, said the following. He underscored that it has been repeated countless times in the literature that if the provisions on the presiding judge's orders preparing the main hearings were applied properly, the litigation would last much shorter. Unfortunately, it must be stated that the judges mostly do not apply them as if they wished for them to disappear from legal life through desuetude, per desuetudinem. Yeah, so these were observations of Professor Gołąb in pre-war period. I think that to a large extent, these observations are still actual. However, as you will see, the reasons are obviously much deeper than a simple reluctance or a simple lack of good will of judges. It's much more complicated than that, and obviously Professor Gołąb understood that very, very well. But indeed, if there are some habits which well predate the Code of Civil Procedure, that former Code of Civil Procedure, which are pretty much based, I think, on this tradition of a very liberal model based on the principle of the parties' presentation, where the parties are indeed the masters of the procedure. A lot has to do with bad habits. But apart from that, there were also serious fallacies of the original model adapted in 1930, and elements of this model were not changed until very recently. First of all, until 2011, the parties were really not obliged to support the speedy conduct of proceedings by submitting all relevant facts and evidence at the early stage of proceedings. So there was an obligation on the side of the court, but there was no corresponding obligation, general obligation applied to the parties. To the contrary, if you look at the former Article 217, the parties were expressly allowed to submit facts and evidence until the closing of the main hearing. The parties, yes, they were expressly allowed to submit facts and evidence until the closing of the main hearing. So is this an element of a concentrated model, or rather almost explicit invitation for the parties to enjoy dilatory tactics, or at least tactics, elements of which is very piecemeal, fragmented presentations of their cases along with the development of the case. On the top of that, also until 2011, there were no comprehensive preclusion rules incentivizing early and complete presentation of facts and evidence by the parties. Apart from the commercial proceedings in which in 2000 there was adopted a strict preclusion model, in ordinary proceedings there were certain powers entrusted to the judge, but in general there were no comprehensive preclusion rules, either in the form of statutory cut-off dates or discretionary power of the judge to disregard belated facts and evidence, even when the delay was caused by negligence or for tactical purposes, unless it was clear for the judge that the only purpose, the really only purpose of submitting some facts or evidence was to delay the case. So this was the situation on the ground. Moreover, till 2019, there was lack of clear distinction between preparatory phase and the main hearing. In the doctrine, it was repeated everywhere that there is no clear preparatory phase. The court has certain discretionary power to prepare the main hearing, but this was what it was. So there were no comprehensive rules governing preparatory, preliminary, organizational hearings, that is case management conferences. Main hearing was scheduled simultaneously with ordering the service of the statement of claim on respondent. So as you can believe, it by itself was undermining the purpose of the preparatory phase. If the judge was supposed to schedule the main hearing at the same time when ordering the service of the statement of claim of respondent, so without knowing the position of the respondent. And finally, till 2011, there were no effective means to effectively manage pre-hearing exchange of preparatory pleadings, that is, to enforce the necessary exchange or curtailing excessive exchange of written submissions. Yes, indeed, when you look at the statutory attempts, the legislative actions taken up until now, it looks a little bit like chasing a white rabbit only to keep falling down the rabbit hole. Currently, we are in the phase of the pending works of the new Civil Law Codification Commission at the Ministry of Justice and its task force on the civil procedural law, as well as the new Code of Civil Procedure. As you, I think, won't be surprised, the concentration of facts and evidence once again is at the heart of these works. I will come back to that a bit later. For the sake of time, I won't describe reforms of 2011 and 2019 in details. I would like to do so, but it's impossible in this time frame. I would simply skip that only to tell the following. As you already know, these attempts have failed to yield accepted results, so as to say. And what are the reasons for that? Of course, it's a matter of discussion. Everybody may have his or her own position on the reasons, but I think that the following reasons are usually discussed. It's a fact that the new procedural model has been resisted by judges and counsels alike due to the following reasons. Usually, at the first place, it's said that there was a poor quality of legislation introducing these new roles on the case management conferences, a lot of over-regulation mixed with under-regulation and ambiguity, lack of proper integration with existing procedural model and solutions. This is what usually is referred to as a reason for a failure. But I think that perhaps the second element is more important, that is lack of proper preparation, education and training to implement that new system which was perceived as too revolutionary, incompatible with the Polish litigation culture, tradition, habits, really dominated by the concept of the main hearing, preceded by limited written preparatory proceedings. But of course, one needs to refer to the overall crisis of the Polish justice system, which is indeed overwhelmed by caseload caused by, in my opinion, truly poor management through last decades. Which includes lack of proper staffing, that is insufficient number of judges, court clerks and other personnel, insufficient financing and inadequate allocation of available resources, insufficient training, and finally lack of comprehensive and efficient digitalization of courts and civil proceedings. Most of their elements, I think, may be treated as a long-standing problems of Polish judiciary, but when it combines with a growing caseload, it leads to a situation in which indeed a proper case management, a proper active judicial early case management, an attempt to engage parties to properly collaborate with judge is simply, I believe, difficult to achieve among judges who have not hundreds, but often thousands of cases in their dockets. So yeah, everybody knows that. I think that the proper active judicial case management needs time, needs effort on behalf of judges. When judge has no time, when he or she fights to survive, simply to survive, it's much easier to engage in a mechanical conduct, avoiding a preparatory phasing and simply skipping to the main hearing, and then whatever happens, it happens. What happens right now in the current works on the Codification Commission? I think that we are coming to the point of disillusion. Besides obvious that existing procedural solutions are imperfect, they need to be changed as dysfunctional, that the procedural mechanism ensuring concentration of facts and evidence need to be established as a crucial element of efficient and fair procedural model. I think that we came to a point of disillusion, a good disillusion understood as understanding that even the best procedural rules, the perfect one, will not suffice to improve the functioning of our civil justice system without eliminating its really severe structural problems. So we may work on procedural rules, we may try to polish them, perfect them, but without really engaging in a real structural reform leading to a proper court management, not just case management, but court management, will achieve little. And I think that there is finally this understanding, which I call a disillusion, a real understanding that procedural rules, even the best one on their own, will not work. Of course, there is also a realization that the best solutions from other jurisdictions must be followed, must be closely looked at, that some best practices, model rules such as ERCP by Eli and Unidroit should serve as a real benchmark reference point for planned overhaul. And it's really seen in the works of the Codification Commission, in the preparatory works, that these documents are really closely looked at. But still, there are main serious dilemma. The main dilemma, I think, is between a direction to try to restitute a traditional model revolving around a single main hearing, supported by the strong discretionary power of the court to disregard belated facts and evidence, which pretty much would mean back to the reform of 2011. And the second direction, I think, which is rather a dominant one, is to try to improve and revive the model adopted in 2019, which has a lot of deficiencies, but if we look at the overall picture, I think that it indeed aligns with the concept that the proper concentration, the real main hearing needs a proper prior preparatory phase. So yes, these are these two partially contradictory directions that still are an element of a broad discussion. I think, with predominant voices towards this second one, that is an attempt to improve and revive this model, which up until now failed to perform. Conclusions. What are the lessons from Polish experiences? How to catch that rabbit, or at least avoid to fall down the rabbit hole? This will be just a very general instructions. So for sure, element of disillusion, best rules on concentration and case management will do very little without adequate court management. So a real deep reform in that regard is necessary. Proper concentration indeed needs thorough preparation and effective sanctions. Effective doesn't mean a very strict, but they must be effective. And finally, proper system of concentration, as anything else, is an element of seeking the right balance between different competing values, predictability versus flexibility, expedition and efficiency versus fairness and substantive justice. Of course, there is no real contradiction between these elements, but this balancing act is, I think, a really important element, which points to the importance of the concept of proportionality in civil procedure, for sure. Thank you very much, and I really look forward to our debate, our discussion. I look forward for questions and remarks on my presentation. Thank you.
Thank you, Andrzej, for your perfect presentation about Polish system and the problems. No, I think that you may stay here, it would be better. So we start the discussion. We've got a couple questions in the chat, but I think that we may start with the questions from the floor, from here. I only would like to say that we've got three main, I think, elements to discuss. The first, this is the question about the model of the concentration of facts and evidences. It means what model would be the best for which jurisdiction. For example, discretionary model. It means when the judge has a discretionary power to decide about which facts and evidences are belated, which are not, or a rather fixed time limits model. It means the model of preclusion. Of course, the importance is what are the exceptions to those models. It means who decide about the exceptional allowing belated material, because even if we've got the model of preclusion, we may create such many exceptions to this rule that in fact it will be the discretional power model. The second one, this is the problem relation of the concentration of facts with the structure of civil procedure. It means what is the stage of deciding about this moment from which the facts and evidences are belated. For example, if we've got some written phase of the proceedings and after that open hearing, or everything is moved to the open hearing or the main hearing, as is in fact in Poland now. And of course, the third issue, which is very important, this is the role of the judge and who will be the judge in the system. He is only the realization of the law and the strict following at the time fixed by law, or this is the role of the judge who is active and who will search the best solution of the case. So I think that it's only for the beginning of the discussion. I think the three main issues which may be in the discussion mentioned. So I open the discussion. If you've got any question, please raise your hand. And of course, introduce yourself and say to whom you would like to direct your question. Have we got? Yeah, the first one, Irina, please.
Thank you so much. First of all, I would like to say it's incredibly interesting presentations, and very exciting topic of this panel. I enjoyed very much. I discovered a lot about national jurisdictions, very interesting things. And of course, my name is Irina Izarova. I'm from Taras Shevchenko National University of Kyiv. So I compare it always with my own experience and our national jurisdiction. We share a lot of very similar things with a lot of discussed previously. And it's extremely interesting to compare how we have mixed of everything. For instance, with Swiss experience, it's fantastic you have this chance to be flexible in procedure, in my opinion. But it sounds incredible that parties can change so many things until the deliberation of decision. We are more strict, like our Polish neighbors. We have something like very strict structure of the procedure, very similar to the first slides described by my colleague Andrzej. And it's always the same problem. Main hearing, like you have in Polish, repeat and repeat numbers of times. Until 2017 in Ukraine, we had chaotic and disorder in concentration of evidence and facts in civil procedure, I confess. Because in 2017-2018, we had enormous reform of procedural law and enforcement and so on and so forth. And after that, a lot of international experts came and evaluated these new rules. And the most important thing, practical implementation of these rules, because there is a very long road from theory to written norms, then from written norms to implementation by courts, by attorneys, and then again to like I would make a circle from that. So we're trying to catch this rabbit. So Professor Van Reye, for instance, he admitted very clearly, you have no end of these hearings, no starting point and no end, and nobody knows on which stage you're finding yourself next time. So, but in the meantime, we had always preparatory stage in Ukraine since Soviet period of time. But practically, judges avoid to dismiss these evidences submitted with violation of these norms. After 2017 and the new reform, we have strict rules on submitting evidences with the first statement. We have, comparing with Fernando, Professor Introductory, I think you can hear me. So we have also something like exchange of statements, but many times. exchange of first statement and then defense to defense and defense to defense of the defendant. But the main rule is to submit the evidence with the first statement. So if you fail with it, you have to explain reasons why you did that and so on. So the general rule is quite about concentration. But practically, and it's about sanction and a lot of other things, judges avoid to use this rule very strictly. So mostly, in most cases, they would be intended to allow to submit new evidences and new facts as well. Before 2017, we had also disorder with changes of claims and causes of action. Right now, it's allowed only on a preparatory stage, but it also depends on case law mostly. So my idea was to not try to catch this rabbit, but just to walk with him. That's endless idea, and it's very difficult to find a proper decision for all cases. We have quite variety of procedures right now in Ukrainian civil procedure, but I'm favorable more with a principle of cooperation between judge and parties, and we introduce a new procedure of settlement with settlement of a dispute with participation of a judge. So to switch the focus, try to not just resolve the case and observe what could happen. Try to push parties to resolve dispute, like it was mentioned in model rules, like help them to make a little bit more flexible procedure, but keep in mind the very task, the main goal of civil procedure. And of course, we introduced, and that was very helpful, specific sanctions for prevention of abuse of procedural rights. That was for such cases, in my opinion, it would be more helpful to punish parties with fines than to just dismiss these evidences, to try to persuade them to behave in more cooperative way with a very idea to resolve the dispute. I'm sorry for such a long intervention. Thank you.
Thank you, Irina. It's a kind of co-report to our session, but it's very well seen because we see how it does look like in Ukraine, in other legal system, which is very comparable to Polish, and the problems are, I think, very, very similar. So have we got any other interventions from the floor, or remarks or comments or something like that? Because I think that it not always should be a question, maybe a remark or something else. I do not see. Of course, yes, you may. Andrzej, please.
Thank you very much. So when I was giving my initial remark, I forgotten about one important, which was not on the slides. But actually, I think it's worth mentioning that when we conceptualize the concentration in Poland, we speak about factual allegations and evidence. In literature, in this context, ability to amend or completely alter the claim as such is not mentioned. Whereas when you read ERCP, CPLJ, or any other comparative sources, it's clear that concentration comprises also this element. If the party is able to modify or alter freely its claim, there is no point in concentration in that regard. And when you look at the Polish Code of Civil Procedure, Article 193, actually there are very little procedural prerequisites to alter the claim completely. There is no need to have a legal or factual connection between the previous claim and the new one. There is no cut-off date. You can do it throughout the whole first instance proceedings, with limitations in the second instance proceedings, as long as it does not affect the subject matter and territorial jurisdiction of the court. So what kind of concentration is that? In that regard, the former Polish Code of Civil Procedure of 1930 was stricter, and there it was also an element of a consent of the counterparty or authorization from the court based on its assessment whether such amendment does comply with the conditions for a fair, truly fair trial, conforming to the needs of equal treatment and so on. This element is well recognized by the Codification Commission and the working groups. In that regard, we are largely coming back to the former model from 1930 with a strong also comparative look at ERCP. So I think that this element is rather not controversial, that the ability to amend, alter the claim may not look the way it looks right now. Otherwise, what kind of concentration we do have if no need for even connection between the altered claim and the old one exists. So I think this is quite important.
Thank you, Andrei. Yes, it's perfect intervention, because as Etienne said, this is the relation with the immutability of the object of the claim relation and the right to be heard. Because if you may change the claim during the whole proceedings, this is also the problem with the right of the opposite side to protect his or her rights, because in every moment you can change the claim and you need to change your defense. So it's really, really, really important. Yeah, please, Michele.
Something to add to this that Andrei was saying now, the friction between concentration and the growing fluidity of the object of the proceedings, which is also a reflection of some interpretation of European procedural notions like lis pendens, back from the Brussels Convention, the notion of same dispute. When you have such a broad idea of same dispute, then the courts might be inclined to do what the Supreme Court in Italy is doing right now, to see that the traditional notion of which went well with concentrated proceedings, we will deal with each claim separately. This leads to multiple claims. In Italy right now, multiple claims, multiple proceedings to be avoided. So the Supreme Court says, well, proceedings should deal with the whole substantial situation at the same time, which of course leads to the amendments of claim, the introduction of basically what used to be considered new claims. What is lacking now in Italy is a reflection from the Supreme Court on the implications of res judicata of this fluid approach to, because from my opinion, if you need to be consistent, you should have a broad notion of res judicata, which so far is not. So concentration is a goal, but I am starting to think that it is becoming almost, a contradiction in terms when you're thinking of civil proceedings as doing justice. So, I am growing an antipathy for preclusions. I used to be a fan. Now,
yes,
in Italy we've gone too far.
You've grown up. Okay, thank you, Tanya. Yes, it's.
So thank you everybody for the very interesting presentations. When you mentioned the White Rabbit, I thought at the same time I had thought about the Red Queen, who tells Alice, that in her country you have to run extremely fast to stay in the same place. And I was thinking whether what we're dealing with is something like that. So whether these rules on concentration of facts and evidence are somehow in need of constant reform because things are becoming more and more complex. But I don't think it's that. Because if we look at the development and history of civil procedure, we've had all sorts of preclusion and concentration rules existing at the same time. And we're basically going round and round in circles. We're not really evolving and running faster and faster. But at the same time, it's obvious that these rules do not really bring about some kind of magic efficiency of civil procedure. I think that has also been clear for a very long time. So I'm often wondering, why are we wasting our resources with reforming these rules when, as you rightly said, it's not really about the procedure, but it's about also, I mean, I'm not saying that the content of these rules is totally irrelevant. I do think that there are some mistakes that you can make, but I don't think that you can somehow magically solve because there are always trade-offs. If you have too strict rules on preclusion, you will have bloated case files, and if you don't have anything, you'll maybe just like drag on and on and on. But I'm wondering, and I don't have a solution, how could we find out what really influences the efficiency of the procedure, because these rules obviously have a very, very small impact, and it's kind of, I wonder how clever it is to invest more and more resources in more and more reforms of these rules that only make everything more complex. But as I said, I really don't have a solution. Maybe we would need more like empirical research, but that's also, of course, has its challenges. but really, I don't think that this will somehow magically solve a big bloating of procedure.
Tanya, thank you. It's a really crucial issue, of course. I only would like to add to this discussion the problem with controlling of the rules about concentration of facts. We know that in Poland we've got a very famous decision of the Supreme Court from 2019 about the consequences of breaching the rules concerning concentration of facts. And the Polish Supreme Court said, very reasonably, that even if the court breaches these rules, and it means allows the material which is belated, it cannot be controlled by the court of the second instance or the Supreme Court, because if you have not any consequences to the quality of the hearing of the case. Of course, it was longer, but it cannot be controlled in the view of the content of the decision. And in fact, if we look at this problem from this side, we see that these rules of concentrations, this is only one way rule. It means if you dismiss some motions and evidentiary motions of the party, you can control that. But if you allow everything, it's not controlled. And of course, the effect is that the court prefers to allow belated material because it's uncontrolled, in fact. Of course, maybe disciplinary proceedings, maybe some other proceeding concerning the length of the proceedings, but it's quite different thing. So it's, I think this is also important. And if I may, because we've got three questions at the chat, they are very, very long, so I maybe only try to focus on the most important, because I would like to give you also the final position to you as a reporter, so you may also mention about these issues. The first, very open, it's about the what is the trend in Europe, in your countries, regarding the issue of the active judge in determining the facts of the case? Doesn't the public law nature of civil proceedings determine the duty of the judge to this regard? It means, what is the role of the activity of the judge ex officio in your country? And of course, what is the influence for the concentration of facts? The second issue, and this is related with the Fernando report, I think, the idea of concentrating managing the evidentiary proceedings before the court in terms of examining witnesses and parties in a short time is very interesting. How does this affect the duration of proceedings in Spain from the moment of filing a claim to the issuing of the decision? As I understand, this is the problem of hearing the witnesses in the one session from the morning to the evening without sharing for a couple of meetings. So what is the influence of this practice for the delay of the proceedings? And the third is, in fact, 5 very long questions, but I think that it's related with the, first of all, the communication by emails and telephone between judges and lawyers. What is the influence, and if it's possible, and how it affects the time proceedings? Of course, this is also the question about the future and introduction of publicly founded incentives for judges who demonstrate exceptional efficiency in case management. It means there are some incentives for judges, for the best judges, as I understand, to promote this active position in the case management. If not, what alternative mechanisms are being considered or discussed to motivate judges to thoroughly familiarize themselves early with the details of their assigned cases, and they to efficiently manage the case? And the last issue concerned the practical challenges of the managing procedural abuses by parties. I think that we mentioned about that, and their legal representatives, despite well-crafted rules on obligatory disclosure of evidence. Are bar association institutionally involved in monitoring or responding to such abuses at an early stage? It means what is the, as I see, the responsibility of lawyers for belated presented of material and abusive actions in civil proceedings. So many different questions, many different issues. So could you respond for them, or I ask our reporters generally about these issues? Maybe Fernando, yeah, you are with us. No, we can't hear you. Could we unmute Fernando? He's unmuted, but we do not hear him. He's not on the... I hear him, but from the tablet. Oh, now will be good, I think. No, it's still a problem. Yeah? Oh, now, Fernando, you're heard.
Oh, thanks so much. Well, I really enjoyed listening to the following presentations, and I'm happy because the landscape is very interesting, and as Tanya said, it shows that we can try to reinvent the wheel as many times as we want. It will still be round and not square. But just addressing the question about how concentration of the taking of evidence has impacted on the length of proceedings, and I would say the change was incredible, especially in the very years after the reform entered into force. So before, nobody knew how long a case would take, since documents were coming one after the other to the table of the judge. Witnesses were examined whenever it was possible for each one of them. So judgments just came when the judge decided to take the case, study it, and make the judgment. After that, there was this practice. I mean, it's also a generational issue. In 2000, 2001, I don't know why, there was a very broad generation of new judges. So there was money to invest, and many young judges were recruited, and they were happy with the new system. So this practice was developed that judges were hearing evidence in the morning and writing judgment in the afternoon. I mean, not as quickly as such, but that was the idea. So in practice, once the main hearing is finished, judgment will come very quickly, because judges have this trend to have everything clear in their minds and write judgments very quickly. So the figures, the official statistic, were very good, and the length of ordinary proceedings decreased a lot, and it was about six months to 9 months for first instance procedure as a whole. Of course, longer in Madrid, because there are many cases, less in other places where the workload was different, but there was a clear and visible impact.
Okay, thank you. Thank you, Fernando. Anybody else would like to say in this context, these questions which were presented in the chat as I read? Michele, yeah, of course, please.
We can't leave questions unanswered. No, very quickly, from the Italian perspective, the role of the active judge, nothing has changed a lot. In ordinary proceedings, we've had the reform, the famous Riforma Cartabia in 2022, also family proceedings, and there we had a quantum leap into inquisitory proceeding. Basically, the judge in that context now by law can go beyond the requests of the parties, normally the parents, can find evidence even ex officio, even over the limits of the civil codes concerning the evidence. So basically, family proceedings where a minor is involved now see a very active role of the judge, of course, not to start the proceedings as such, but then you have the public attorney who is himself or herself a judge who can do that if the conditions are met. So that's now a whole new area when we are dealing with a very active judge. Then I found it interesting what Piotr was saying about the sanctions against new. Well, actually, in Italy, there's a very strong reaction. The Supreme Court says that new evidence, new facts are inadmissible, and the parties cannot even agree on overcoming peremptory deadlines. So if they fail to do something within the given time, even if they agree to do it later, that's inadmissible. And such inadmissibility can be raised as a ground for appeal. So it's a whole different situation. That's why we are so concerned about preclusion, because if you well, it's late, so I will not go into the details. And then something which, well, the question about emails, we do, as lawyers, sometimes write emails to the judge, but never to discuss the case. Always with the other lawyer in CC, and usually to say we found an agreement, so we will not appear in court, or we have filed this joint petition to postpone the hearing. So always something dealing with the course of the proceeding, never the merits. And if you do that without the other part, that would be. And I've never been on the phone with a judge to deal with a case. I know that in other jurisdictions in England, this can happen where we don't do that. And then to finish, something related to what Fernando was saying. In Italy, and I guess elsewhere, the problem with reforms, even the best reform, is that the judges who have to apply this reform do not only deal with the new cases. They don't start with a fresh, backlog. They also have to deal with the old cases. And that, of course, makes even the best, the more advanced reform impossible to work, because you need to, basically concentration requires the judge to go to court prepared. That's what Fernando was saying. Not to prepare as to have already written the judgment before going into court, and this can happen sometimes. So as a lawyer, you feel useless because the decision has already been taken without you opening your mouth. But to be prepared, you basically need time. So the problem is always, that's the century-old problem of time.
And Michele, so this question about bar association reactions against some dilatory actions of lawyers, because you are attorney and.
Well, we still don't have. It will grow in time, I think, because now in family law proceedings, there's a provision which says that if the parties do not give the documents required, they fail to cooperate, and that can be sanctioned in the proceedings. We haven't gone as far yet as to say that this can also look back on the lawyer, but we could go there. I think that now we are starting to have some problems with lawyers using evidence from the clients which have been obtained in a legal way. Now with recordings of conversations, not unlawful video recording, this is growing in family law, but not only in family law. And lawyers use a lot of these documents. And this, I think, now will become a problem very soon. It's a different topic, but related.
Yeah, thank you. This is the ethical also problem. Yeah, Tanya, please.
Yeah, so in Switzerland, the active judge is not really a thing, or I would say judges structure the procedure formally, but they are pretty reluctant to be active in regards to kind of actual case management, and I think that is, and also I would say the idea that the purpose of the procedure is to find the actual truth is viewed with a certain degree of skepticism. So there I have even heard presentations saying that the formal truth is what civil procedure is about, and therefore also, I mean, what you said about the sanctions is of course logical in a system that is about the material truth. But if you are about the formal truth, then it's much easier to say, well, that was inadmissible, so you cannot consider it when giving a judgment. And that would also be the Swiss approach. So, but about incentives, I think in Switzerland, incentives for judges are very important, not even necessarily positive incentives, but negative incentives, because it would be very much frowned upon if the procedures were very long. And there are always reports about how long the procedures are, and judges are very keen on finishing them quickly. And I think that is probably much, much more important than the procedural law, that there is really an attitude that you have to finish the procedures quickly, and that, I guess, is one of the reasons why they do.
Yeah, thank you. But I think that this responsibility of judges and the control of judges is in the hand of cantons or of the federal government?
It is different, it depends, but mostly it is the cantons, and often so the cantonal superior courts will supervise the lower courts, and there is also supervision then by the cantonal parliaments for, And I do think that this is important. I mean, about procedural abuse, I guess the more norms you have, the more you then quarrel whether they were violated. So in the US, you have a lot of this sanctioning of lawyers for procedural misbehavior, but that then creates a whole new range of procedures and hearings and decisions and appeals and whatever. So you can wonder whether it really, how much good it really does. But yeah, I mean, you could, of course, at least have it somewhere in the background to say, well, take care, be careful. But if it suddenly becomes a big thing, then you have a ton of procedures about ancillary issues and are no longer discussing about the cases.
Okay, thank you very much. Somebody else, Etienne, would you like to add something? Yeah.
Yeah, maybe three things. First, on the idea of public law, civil procedure, and active judge. In France, it has been at the core of the reform of the French Civil Procedural Code, but for the lawyers, it's still a private law matter. And we still have this liberal, subjectivist approach to civil procedural law, and we gave all those powers to the judge, and the juge de la mise en état is one of the most powerful judges today, but he is not really very active into seeking himself or herself evidence without being asked. So ex officio activity is really textual existence, but practically it does not really exist. Depending on the matters in family law, it is a bit more active and things like that. But generally speaking, procedural law in France is still private law. Second, about the incentives, we have 12% of the salaries of judges that are proportionate to their activities. And so it's a big incentive, since 12% can be a big figure, but a lot of it is depending not on their activity instructing the case or in evidential measures, but in ADR, promoting alternative dispute resolutions. Because in France, we do not have any obligation to arrive at the court with a ready case, but we are trying to build this readiness by enforcing an alternative, a mandatory alternative dispute resolution before engaging in public court. So your case would be ready even if it failed, because you would already have tried to build an argument and discuss the case outside the court. So what we are trying to do is to do another pre-trial phase, but via the settlement, which is in France completely inefficient. We have less than 4% of settlement in civil law matters. So it's really weak because it's not culturally implemented yet. And the last idea is about formal and material truth. We, of course, for a long time, and for everyone that is believing that the procedural law is a private matter, we are not trying to figure anything scientific, anything like material truth or one truth against everything would be erroneous. No, this for a long time has been frowned upon, but we have this case law coming from the European Court of Human Rights on the right to evidence. And in France, we have had a decision in December 2023 building the right to evidence against unfair evidence or disloyal evidence. If it's the only mean for you to build your defense, you can produce stolen evidence or something disloyally obtained. You can produce it. The judge will have to do a proportionality test between the disloyalty and your right to evidence, because the right to evidence in France, and since the case law LL versus France of the European Court of Human Rights, is connected to the right of action, to a fundamental right. So you have a fundamental right to produce stolen evidence in France today. So there is this tendency towards some material truth that could be obtained, and the legislator and the Court of Cassation seem to be thinking that it is more important than the respect of controversial method and adversary principles. So we are going towards something more material truth connected, and this is changing the way to approach also the concentration that we do not have, but there is no risk of having it, since now we are building the right to evidence at any time and at any cost. Thank you.
Okay, thank you. Yeah, thank you for your intervention. It's great, but
good afternoon. We are starting now the second panel, the second section of our today conference. The topic of this section is AI systems in judicial case management of today and tomorrow. My task as a moderator is only to keep the running of the program and keep the time limits. But since I have the floor, I would like to begin this panel with few introductory remarks. First of all, we need to know what we intended to talk about, because in the title of this panel is used term artificial intelligence. But what does it mean, artificial intelligence? According to the literature, we can find that there are 7 types of artificial intelligence, from narrow intelligence, it is weak intelligence, then strong intelligence, and the most developed is, I think, generative intelligence. I mean by saying that these are the tools of artificial intelligence which are able to create new content, and this is the most interesting for us. And it should be noted that the term artificial intelligence was coined by John McCarthy in 1956, so it was almost 70 years ago. 70 years ago, it was introduced into the language of research exchange. It was at the Dartmouth conference. Now this notion is commonly used, but yet many consider it inappropriate. I've got the colleague who thinks that there is no something like artificial intelligence. Intelligence is strictly connected with the human being, so there is no something like intelligence which is connected with the subject which is artificial. But, however, there is no doubt that the use of generative artificial intelligence is one of the leading challenges of our time. So I would like to congratulate Professor Andrzej Olaś that he chose this topic as the second section of our today panel. It is worth mentioning also that last year, International Academy of Comparative Law in Paris has accepted the issue of artificial intelligence as the topic for the 22nd International World Congress in Berlin, which will held in 2026, and together with Professor Olaś and Professor Michele Angelo Lupoi, who are present here today, we will prepare general report for this Congress in Berlin, which will be based, this report will be based on the national reports coming from almost 30 states from different continents, and this indicates the strong interest in this topic. Yes. But given the speed with which AI tools are being developed, I know that it is very difficult to explore the problem in social sciences, including the legal sciences. Such swift transformations of legal tech are leading some experts to express the opinion that the problem of the use of AI is not worth to be considered. It's because the thesis which we put in our dissertations, in our articles, can be out of date before they go to the print. Yes, so it's difficult to conduct scientific researches. But I don't share this opinion. Artificial intelligence poses so significant threats to civil justice system that I think that it is our duty to identify these threats and to propose adequate solutions for the future. And two more problems. First is the perception, the public's perception of the civil procedure, which is based on artificial intelligence tools. Each civil procedure, regardless of whether it is based on artificial intelligence, whether it is not based on these tools, should realize procedural values such as human dignity, equality of freedom, equality of freedom of participants, and procedural rationalism. So this is a very important problem from the axiological point of view. And last question, it is loyalty. It appears the problem how the loyalty can be respected when the participants to the civil proceedings don't know the basis for the adjudication. It is connected with the problem of black box nature of artificial intelligence. And the principle of loyalty is the question which is especially now considered in the procedural law. So there are also other problems, but I think they will appear in the reports. So I think, concluding that that is the challenge which requires new solutions and which deserve our work during this conference. So we can start with our reports, and the first speaker in this section is Professor Bartosz Zieliński from the Jagiellonia University, and I give the floor to the professor and go on.
Thank you very much, Professor Cieślak, for this introduction. And I would also like to thank Professor Olaś for the invitation. It's visible? Okay. So maybe I'll close this. Okay, it's working. Okay, first of all, as I said, I would like to thank, and I would like to say sorry, because half of my family are lawyers, and they always say that I'm speaking too slowly, and they speak very fast, so I will speak in my tempo, so I'm sorry for that. I would like to also introduce myself. I am a professor at the group of machine learning research at Jagiellonian University, and my team is especially dedicated to artificial intelligence and explainable artificial intelligence. So how to explain the prediction of neural networks. And today I would like to explain, like in a simple words, I hope, what is artificial intelligence, what is explainability, and ask a few questions. But before, explaining explainable artificial intelligence, let's go back to the definition of artificial intelligence that Professor Cieślak talked about. There are many definitions of artificial intelligence, and one of them I put here is from Britannica. And the first part is quite obvious. So it's a kind of machine who has some symptoms of intelligence. So works in some kind of intelligent way. However, the second part that is visible here is, I don't know if I have like pointer, no. The second part here is that till now, no program exists that can match full human flexibility over wider domain or in task requiring much everyday knowledge. And this is true. I mean, we have some specific expectations when it comes to artificial intelligence, because we saw many movies, right? And I would say that generative AI, large language models, somehow can fit these expectations, right? And I'd like to say about last research that was published recently, which showed that ChatGPT passes Turing test, okay? I don't know if all of you know what is Turing test. It's presented in this slide. So it's like participants chat with two instances, like they chat with human and ChatGPT in this case, right? And they do not know with whom they chat. So they chatted 5 minutes with one of them and 5 minutes with the other. And it turned out that ChatGPT was better in pretending human than humans. So 73% of time, right, ChatGPT was mistaken as a human. So human was correctly classified as human only in 27% of cases, okay? So we can say that, you know, we are above this border, that where the ChatGPT passes Turing test. Of course, this research has some limitation. It's 5 minutes, right? So maybe if somebody would talk longer, maybe the result would be different. How does it look in other domains, right? Because large language model is like one domain. It's a verbal domain, right? When we discuss with somebody, with words, right? But how does it look in robotic, for example? When in robotic, you can see this photo. It's from 2023. It's a K5. It's a special robot to go through the metro station in New York. And, you know, what can it do? It can go through the station, like right through the station, and record what is happening, right? This is, in fact, what is, how the situation looks like when we talk about robots which operate in real world, right? It's a long way to this slide that I showed before. So in some domain, the expectations are okay, but in some domain, we are far away. So what is the success of current artificial intelligence methods? Well, to tell about it, I would like to say first what this method use, because those methods usually use neural network, artificial neural networks. And to say what are artificial neural network, I would first like to, you know, talk a few words about biological inspiration of artificial neural networks. So it's like in our brain, right? There are neurons, and neurons are connected with synapses, okay? So synapses are connecting one neuron to another. And here you can see, right? There is a presynaptic neuron which passes the information to the postsynaptic neuron, which receives the information and passes to other neurons and so on. And this way I can talk, I can move my hand and so on. And there is you know, enormous number of synapses in human brain. It's 100 trillion synapses. I will in a second say how it compared to ChatGPT. But how does it look in artificial neural network? Where in artificial neural network, it's similar. There also are neurons, which passes the information to successive neurons. So there is a neuron here, which is this big sigma sign, right? And it gathered the information from other neurons, which here are the smallest circles. And then, when he gathered the information, he's activated and moved this activation forward. And in case of artificial neural network, the structure is, there is a structure, because we need a structure to optimally train neural networks. And the structure is as follows. There is a first layer, neurons in first layer passes information to the neurons of the second layer, neurons of the second layer passes the information to the neurons of third layer, and so on, right? So there is no connection everything with everything, right? Like in human brain, but there is a structure. And without the structure, we do not have a possibility to train that kind of methods. GPU doesn't work, would not work for human brain. Okay. And it's not that here you can see that there are 5 layers, right? 5 layers of neurons, but large language models using hundreds of layers, right? With thousands of neurons. So there's a lot of them there, right? And they pass the numbers to each other, right? So we have some input, right? We have some output. I don't know, the input can be image, the output can be text, right? Cut on the image, right? And we do not know what is happening inside in the end, right? There's a lot of bunch of, random numbers that passes from one neuron to another, right? So it's quite disturbing, I would say, right? Because sometimes networks should, predict something which can have big influence on our lives. So it's somehow worries people that we don't know what is happening there. And this is how I just wanted to show how it works in the large language models. So in the large language models, we have some text, for example, how are, and we have to predict next words, right? And model for each word in the dictionary, he will predict the probability of this word, right? And probably the highest probability for how are will be for the word you, right? That's why he will end this sentence, how are you? But how he does it? Well, he runs this, huge network with a lot of neurons, and nobody knows what is going on there. So there is a lot of neurons, there is a lot of artificial synapses, so we can say, is AI better than human, right? So we can say, which one is better? Will the human win, or will the ChatGPT win, right? And it depends, right? I mean, we can talk about better in many levels, okay? The first level is the number of synapses, right? So how many connections there are between neurons. So in a human brain, it's more than 100 trillion synapses, right? ChatGPT 4 had 1 trillion synapses, so 100 times less synapses. But for example, ChatGPT 4.5, and it is estimation because, as you know, the model is closed, so we cannot say exactly what is the number of parameters, but it's around 12 trillions of synapses. So 12, and so close and close to 100, right, in human. Will ChatGPT 1 with human when he have 100 trillion synapses? Well, we can say that it's already winning on some levels, right? I mean, it can generate maybe nicer text and so on, right? But it does not operate in the environment, for example, right? We cannot say ChatGPT go up on the stairs, right? Because, well, even if he would have some kind of embodied robot body, right? If he would be embodied with robot body, then it would be very hard for him, for example, to understand the geometry, right? If he, in ChatGPT 4, he was not able to say, if he saw the picture of ball and triangle, to say, is the triangle on the right side of the ball? he was not able to answer that kind of question, right? So he is learning what we, you know, as a human, more know about the world. Right now, people try to train chat bots, things like that. And also the other things, why human brain is better, well, there is no structure like in case of artificial neural network. All the neurons can be connected to all other neurons, right? If they are close enough, of course. And this way, you know, human brain is much more like economic in case of energy consumption, right? ChatGPT, to be trained, needs a lot of energy. So if we answer the question how artificial intelligence works, we somehow try to answer, is artificial intelligence better than humans? Maybe we should, and we saw that in some point it is very close, maybe we should ask a question, should we control it, right? So, as I said, artificial intelligence is considered as black box, so it can produce many problems, right? And I just, you know, randomly choose some problems with artificial intelligence that appeared on the network, on the news. So imagine you're on a trip and the driver suddenly takes an unexpected route. You might ask why, expecting an explanation, right? We expect similar explanation from self-driving cars. Right? So, possibility to explain his decision, to control his decision, because if we know how he works, then we can somehow try to control him. No control can result in many problems, because, for example, racist, this problem can be racist, this problem can be chauvinistic, and this is because there is a bias. There exists a bias in large language models, and this bias is caused by the bias which exists in data. There is a famous article which says that when we talk about bias in AI, we must remember that computers learn from us, right? So we as a society are biased. So the question is, do we want model to be biased? No, we usually not, right? So how can we control artificial intelligence? This is the next question that can appear. And some of you can say, well, when he predicts something, maybe we should ask him why he predicted it, right? You ask ChatGPT, what should I do? Should I buy a new car or should I pay my loan, right? And he said, you should buy a new car, right? And you ask why, right? Because it's important for you, you will develop and so on, right? But we don't really know why he answered like that, right? Maybe he answered like that because, you know, some companies want us to buy a new car instead of paying our old debts, right? So we should not ask ChatGPT why he predicted something, why he proposed something, because then we get something that we get when we ask a teenager why he smoked a cigarette, right? He will storytell. He will try to say something that would please us, right? My colleague forced me to smoke the cigarette, right? This is something that he do because he was trained like that. He was trained to answer the question that please us, right? So by asking him about the explanation, we will not get the real answer. This is very crucial. However, there exists a whole community that try to explain the prediction of artificial intelligence networks, and there exist many methods. One of the methods is shown here. It's called LRP. Here we can see that there is an image of rooster and that the black box model predicts a good label, rooster, right? So he was created to classify the image, and he classified it correctly. And then using this method, which tries to go synapse by synapse from the prediction to the input image, we can see which part of the image was important for this prediction. In this case, the head of the rooster was the most important for this prediction. So we can say that that was good, like this prediction was for a good reason, right? Right prediction for a right reason. But there are also right prediction for the wrong reasons. There is another explanation from different methods called LIME, okay? And this explanation shows why network predicted label wolf when it saw the image of husky. And as you can see here in the image, the model mostly, focused on the background. The background was snow. Well, most of the images of wolf he saw was on the snow, so he predicted this also as a wolf, right? So this was wrong prediction, right? In this case, we can find the biases in the models. And one can we do when we find the biases? For example, here we can see different bias when he predicted, doctors as men were doctors, women were nurses, right? And he mostly looked, as you can see on the middle column, he mostly looked on the face, right? When he predicted the profession. So what can we do when we find the bias? Well, we can correct the model. We can remove the bias from the model, and we can obtain a better model which doesn't have that kind of biases. And you can see it on the right column, right? When he classified the object, he looked on the correct things, right? Like the color of the uniform, right? Because the doctor has white uniform, nurses have green uniform, USA. Green? Not green, sorry, blue. Yeah. So, and how can we do it? Well, there are specific methods called unlearning, where we unlearn biases. And here you also have an example of other biases or other things that we can unlearn. For example, we may unlearn the model to not answer the question how to create a bomb, okay? This is, it's not good that LLM has that kind of information, right? We'd like to remove it from the model. Or maybe information about some specific persons, right? We also would like to remove the information about them. So, to summary, modern artificial intelligence uses artificial neural networks, which are extremely complex and operate as black boxes. So there is a lack of understanding how they work, and this can lead to decision being correct for the wrong reasons. And it is crucial to understand, and that's why the explainable artificial intelligence is developed, and many researchers work on that. So thank you very much for your attention.
Professor, thank you very much for a very interesting presentation. I think that it will be very, very useful for our next considerations. So thank you very much. And now I invite Dr. Julius Schumann from the University of Vienna. And now we'll be considering problem of the current status and future developments of the use of AI in courts in Austria, Germany, and Switzerland.
This one. Thank you very much. First of all, thank you very much for this great conference so far and for inviting me for today to give a short overview of the current status and future developments of the use of AI in courts in Austria, Germany, and Switzerland. That means I will now move from the more technical perspective we had in the last presentation to the user perspective and to the perspective of how to implement AI in the workflow of courts. And I can say up front that courts have more than maybe someone would expect implemented AI at the moment already. I would like to make a certain categorization of the current applications of AI in judicial work. I have divided them into 4 categories. The first one is electronic communication and file management. Then we look at the immediate decision support, the publication of decisions, and also how AI can aim in improving the access to justice. As you can see already, I've intended to set aside the issue of fully automated decision-making in today's presentation. That's the reason why it's marked in gray. This might be surprising. While there is this topic certainly draws attention, none of the countries I will present today has expressed a clear desire to pursue full automation. The most recent report, even by the European Commission for the Efficiency of Justice, published in February 2025, also explicitly stated that fully automated decision-making is currently not being used in any of the member states. Even recent proposals in the German debate on civil procedural reform, such as the idea of a zeroth instance, meaning an automated decision at the beginning of the proceedings, have been widely rejected in the academic literature. I will therefore focus mainly on areas of application where the most significant developments in the Austrian, German, and Swiss civil justice system is happening at the moment. By postponing the topic of access to justice for later, as it's not the key topic of today's conference, I would like to start having the course of civil proceedings somehow in mind with electronic communication and file management. A recent development in all the countries I'm presenting today is the digitization of paper files. The progress in this regard varies across the named jurisdiction. I would say Austria is in the lead at the moment. Just to mention, in Austria, lawyers have been required to submit written submissions electronically, I would say, for nearly 2 decades now, while in Germany, for example, this obligation has only existed since 2018, and in Switzerland, such a requirement is expected to be upcoming in the next years. Full digital communication, of course, is not an AI topic per se, but it facilitates the reuse of file components later on during the proceedings for the judge. To this end, digital platforms are currently being developed and planned in Germany and Switzerland to handle all communication during the proceedings through a single system. Austria has a platform of the judiciary, though it is primarily aimed not at legal professionals, as in Germany and Switzerland, but at laypersons, enabling them to have access to their files or even to initiate proceedings through this platform. In particular, AI can assist with the intake of written pleadings by automatically and flexibly extracting metadata, such as parties, values in disputes, and typical case-specific information. And this is already being implemented in many German federal states. A notable example here is Smart IMG, the Smart IMG project in Bavaria and Rhineland-Palatinate. You may not be surprised to hear now on all the other slides as well, references to individual German federal states or to Swiss cantons, which is the result, I have to say, of the judicial organization in these countries. Austria has also implemented similar AI-supported metadata extraction as mentioned. A further step is the AI-supported structuring and searching of case files. Since this often involves direct assistance to judges in decision-making, I will return to this point again in a minute. Less discussed, but still important, is the use of AI in speech recognition. This alleviates, of course, the burden on court administration, which still often manually transcribes dictations of judges or the parties. In cross-border disputes, I would also say AI-assisted translation tools also increasingly used, though not specifically developed for the judiciary itself. When talking about file management and electronic communication, we are still within the domain that would usually not constitute a high-risk system according to Recital 61 of the AI Act. This is, of course, different as soon as we move closer to the core of the decision-making activity, although the exception under Article 6, Para 3 must still be taken into account in regard to these tools. However, I would like to point out that the AI Act is, of course, not the end of wisdom. I would say it's somehow a minimum regulation besides all the national law in the area of justice. At least the CPG report also pointed out that the AI Act does, of course, not sufficiently address the specifics of the judiciary and also its fundamental principles. By that, let us now move closer to the core area of legal decision-making, and by that I will return to the preparation of case files I've mentioned before. AI is increasingly being used to enable substantive pre-structuring and to facilitate intelligent search within the case files themselves. For instance, the Codify project, this is a project at the regional court in Frankfurt, is already in use for mass proceedings such as the Dieselgate claims. Similarly, the Struki and Akira projects of the Ministry of Justice in Baden-Württemberg serve the same objective. And also the Higher Regional Court of Stuttgart uses a specialized AI tool for Dieselgate claims called Olga. They are very frequently using women's name for this AI tool, so I'm not sure why this is the case. Olga extracts key elements such as vehicle and engine types, mileage or purchase prices from legal documents. All of these systems aim to help judges quickly familiarize themselves with a case file and efficiently find and use relevant information in their decisions. Once central legal questions have identified, maybe with the use of AI, judges will then examine whether relevant literature or case law already exists on those issues. So now we are moving on to legal research, and this is one of the areas where numerous of AI applications already exist. It is useful here to distinguish between usually more advanced external tools provided by private vendors, tools judges may use autonomously, and those developed internally within, respectively, especially for the judiciary. What we usually observe is that they differ in the data available. Databases offered by the publishers, for example, contain not only published case law, but of course also literature that is not publicly accessible and therefore is usually not directly available for tools developed by state actors. From a technical perspective, at the moment such private database providers in Austria, Germany and Switzerland focus on semantic search, that means adding context to queries, and on enabling interaction with the content such as chatbots, which we are probably all using at the moment. Interestingly, both the Swiss Federal Supreme Court and also the Austrian judiciary as a whole have also now introduced chat-based interfaces for judges to interact with their decision databases. Additionally, AI can also identify, of course, citations in written submissions, providing direct hyperlinks to the corresponding literature or case law entries in private or public databases. Both internal and also external developed tools often suggest similar case law to support judicial reasoning, yet some tools are more specialized, of course, on specific claims such as air passenger rights, as we will see. Also, AI-generated literature is no longer a theoretical concept. A recent project by the Max Planck Institute in Bonn, for example, created a legal commentary without a human author. Using ChatGPT and prepared datasets, I have to admit, by the German Federal Constitutional Court, they generated actually a commentary on a single article at the moment of the German Basic Law, with references to relevant case law. While the resulting text, of course, lacks the depth of a traditional legal commentary written by scientists, its broader coverage of Federal Constitutional Court jurisprudence may offer value to courts seeking more comprehensive case law coverage and case law citations. It is, of course, also the potential of AI-supported information retrieval that we see in these cases. Let us now take a step further towards AI-assisted drafting of judicial decisions, an area where Germany currently plays a leading role through numerous pilot projects. As previously mentioned, fully automated decision-making is not foreseeable. This is different, of course, when we look now at the mere creation of drafts for decisions that judges can build upon. In this regard, it's crucial to understand that AI is not synonymous with generative AI, as we have already heard before. AI can also be used to simply analyze input texts via natural language processing and identify and compare, of course, existing texts. This reflects that AI is for now primarily used, I would say, at courts to improve information retrieval, meaning retrieving relevant case law and literature from different sources, an everyday task of legal research we are doing all in our offices. Initial efforts in this domain were motivated by the increasing burden on courts to produce repetitive reasoning in identical, or I would say very similar cases. We are speaking here of mass litigation arising from claims such as flight compensation or Dieselgate cases. The goal is to technically implement case law consideration through categorization of a typical case group, and in the next step, drawing from that typical case group to suggesting formulations based on similar decisions. In this context, early experiences were made with the AI system Frauke, used at the Regional Court of Frankfurt am Main for air passenger claims, which provides text modules for decisions as described earlier. A similar system developed by the startup Okos is to be used at the Regional Court of Efferding, which has jurisdiction over the Munich airport. However, like Olga, these systems are limited to specific fact patterns or legal claims, air passenger rights, Dieselgate claims. At the federal level, the German Ministry of Justice is now working to move beyond such specialized solutions and toward more flexible applications. One example is the already mentioned Struki system, which is also intended to support cost decisions in mass litigation. Another, for example, is Maki, a project of the Federal Ministry of Justice, which aims to create a more flexible solution than Frauke. Maki is designed to independently identify patterns in similar cases pending at the court, of course limited to the same judicial panel, and alert even judges to potential mass litigation trends. It then suggests relevant templates for decisions and automatically customize them via one-shot annotation. That means that the annotation is used based on a single sample case that is manually filled out by the judge and then is completed by the AI in all similar cases. Of course, in the context of drafting decisions, generative AI also holds potential. Chatbots with access to databases of judgments and literature were already mentioned. But moreover, the German Ministry of Justice is currently developing a large language model with scientific support from the Technical University of Munich and the University of Cologne. The goal is to offer a flexible tool to support judges in various tasks by their own large language model. Identified use cases include at the moment structured presentations of parties' arguments in case files, summaries of key legal principles from higher court decisions, and even the drafting of case headnotes. This leads us directly to tools assisting in the publication of judicial decisions and also the anonymization. As the public interest in access to decision increases, courts have long faced the challenge of anonymizations of many, many cases. Accordingly, all 3 countries now employ IA-based anonymization tools. Austria, Germany, and Switzerland, all of them do, but though not yet all courts in Germany and Switzerland at the moment. These have proven more reliable than manual processes, which are often error-prone. The slide has now an example of the Bello AI. This is a tool that is offered for the regional courts of Aargau and Bern. Identifiable elements are marked here at the interface, and they're suggesting that they should be anonymized, and then the judge has to approve this in the last step. In Austria, the software is already deployed across all civil courts. As a result, final judgments from appellate courts beyond the Supreme Court, whose decisions have been published for many, many years now, have to be published as well. As mentioned, this decision may be paired with automatically generated headnotes using software tools like Justice, like the large language models by the Ministry of Justice, and also Alex in Germany. This is an anonymization tool and also a tool for creating headnotes. While the anonymization is, according to recital 61 of the AI Act, not a high-risk system explicitly, that may differ in cases when it's combined with also creating headnotes from my point of view. But of course, we also still have to keep in mind that there is the exemption of Article 6, Para 3, and I would say this is just a singular task which may can be subsumed under this exemption. As mentioned at the beginning, just a brief word on AI and access to justice. Legal tech solutions frequently promise to facilitate mobilizing law and rights. A main area of focus, because maybe they are just less cost intensive, are websites or platforms offering chatbots for legal information or assistance with court filings. However, as far as I'm informed, no such chatbot really exists at the moment in Germany, Austria, and Switzerland. Of course, for several years, Austria offered a chatbot on its Justitia platform, but this was just recently discontinued, and I inquired with the Ministry of Justice why did it stop this chatbot. The first reason that there was no funding for this chatbot anymore, and another reason was that the usage was actually too low, and this was reasoned by the very, very limited functionality. So maybe, as some argued, that using chatbot is just picking low-hanging fruits, maybe that's not enough. Maybe we have to invest more money if we really want to really aim to improve the access to justice, maybe not only in AI. And just to mention this very quickly, combination of platforms and procedural assistance do also exist in Germany through first pilot projects regarding online proceedings, but those online proceedings are usually not combined with any AI tools. After this brief overview of the different fields of application of AI in the judiciary, I would like to conclude with some reflections and look ahead. First, while the so-called AI judge or robo-judge, if it ever materializes, is still a distant prospect. AI tools are already being used, however, to take over traditional tasks of legal clerks and judicial assistants. Such tools are being developed by both, as we have seen, private and also state actors. Germany in particular showcases numerous university collaborations in which universities are directly involved in technical development. This reflects a broader trend of law faculties contributing to product innovation, something already more common in the natural sciences. Moreover, in jurisdiction with federalized judicial system, we see a common problem that there is a risk of developing new solutions for the same problem instead of using already existing ones. This is apparent in Germany and Switzerland, and I would say it's a very, very cost-intensive way when talking about AI. And Germany, in response to that, has launched a One for All initiative now in collaboration with the federal states, aiming to make 2 new tools developed in one state available to all the others. Put provocatively, one might say that the judiciary is currently merely reacting to the rise of mass and complex individual proceedings in which law firms themselves are reportedly already using AI tools. There's of course a risk that this is just a mere attempt to fight fire with fire, but I would say there is no other option for the judiciary at the moment. And it's likely that investment in legal tech within law firms, especially for mass claims, will remain. In terms of access to justice, the judiciary is also mirroring developments in the private sector. It's positioning itself, sometimes with the help of AI, as a provider of a broader service, such as preliminary assessments in areas like air passenger rights, for example. Tanja Dome has just recently cautioned against such blurring of roles in der Gutachten zum Deutschen Juristentag. Nevertheless, the judiciary is now catching up, albeit late, I would say, in areas where private providers have long since built viable business models that go far beyond primarily legal assessment. Let me close with one final observation. Computer-assisted legal research is not new. Austria, for instance, has used such systems since the late 20th century in the judiciary. Yet the relevance of methods, how to find and identify relevant judgments and case law, meaning information retrieval, has long been neglected as a relevant subject of legal science, confined sometimes to in the German-speaking science underappreciated field of legal informatics. The current discourse around AI places the technical aspects of information retrieval at the center of attention. This might be a welcome opportunity to reconsider how we wish to design legal research and reasoning for the future. Thank you very much for your attention.
Thank you very much, Doctor, for your very interesting presentation. I think that this, particularly translations in cross-border proceedings will be very useful in Europe, particularly in Europe. And now it's the time for the presentation from France. Can we link with Professor Emmanuel Gelin?
Hello, can you hear me?
Yes, we can hear you. The floor is yours. Have you got the presentation or no?
Yes, I've got a presentation, but I've a problem with my computer. I'm trying to share the presentation. I don't have my usual computer, I'm sorry. I'm looking for the sharing of presentation.
Yes, we're waiting. We're waiting. We can hear you and see you, and we are waiting for the presentation.
Sorry about that. I don't see any more. No. Where is it? Because I'm not used with Teams. I used usually another one. Right. So it's very difficult.
Okay, Mr. Professor, we see your screen, so you are sharing with us already. You need just to...
Okay, you see my screen?
Yes, we just need your PowerPoint presentation.
Okay, okay. So it should be...
You have opened it already.
Okay. Does it work?
Yes, yes. It works. We can see it. Yes.
All right. You can see, can you see?
Yes, yes, we can see, and the floor is yours.
All right. Thank you very much, and thank you very much for your invitation. Thank you very much, especially to Professor Andrzej Olasz. I'd like to present the current status and future development of the use of AI in courts in France. And I would like to try to not only describe what is the use of AI in court in France, but try to connect it with procedural thinking, procedural theory. There is a big buzz in France, as I swear, about AI in justice. 10 years ago, we had a big discussion on predictive justice, but then it didn't work very much. And so now we have many solutions for lawyers. LexisNexis France, Dalloz, which is probably more specific to France, and something which is called Doctrine.fr, which has recently been condemned for unfair competition by the Court of Appeal of Paris. It means it shows that it's a very competitive area. The Court of Cassation has released a report in April 2025 saying that the judge, the judiciary, needs to have the same tool as lawyers to catch up with lawyers, as said Mr. Schumann, my colleague, Professor Schumann, but they need some internal system of AI, especially when it involves information to be given. If a judge make a prompt, the prompt is going to be an information. So for reason of confidentiality, courts cannot use AI as lawyers. I'm going to have some reflection about the goal of AI in court, and I would explain that AI is about administration of justice, not adjudication. And then I will present some use cases of AI in French courts, present and future. Sorry to say something very obvious, but I need it, at least for myself. AI is not intelligent. Mr. Professor Zelinsky had this said it earlier. It's a calculator, a very, very powerful calculator, which transforms everything in 0 and 1. So it's a discrete process and not a continuous one. If you listen to music in live, it's continuous. If it registered digitally, each sound is pixelated in 0 and 1. So there is a loss in comparison with the continuous process. A vanishingly small loss. But the lawsuit is a continuous process as well. So we are always going to have bias and errors. There would be some improvements, some big improvement, but bias and errors are inherent to AI. I am using the relationist approach of procedure coming from Germany, from the 19th century, Bureau and Color. And as you see here in this triangle, we are the parties, claimant, defendant, and the judge. And there are 4 legal relationships. The substantive relationship about tort, contract law, family law, and so on. The procedural relationship between parties. And then there are 2 others. The adjudicative relationship between the judge and the parties. The judge has the power to adjudicate. The parties has the right of action to get a judgment. And there is an administrative relationship. I think AI is concerned with administrative relationship. In the judicial method, we have to present the facts, to take evidence, to find law, to make interpretation, discussion, adjudication, and almost nothing can be really made by AI. There is a small role of AI in adjudication. AI may not interpret law except find a case law about interpretation, which is something else. May not create a new case law, may suggest an emerging solution, which is different. May, as that's true, help for the taking of evidence in discovery or equivalent of discovery in civil law countries, may help to write the judgment, but not exactly the legal reasoning. Whereas the administration of justice, this administrative legal relationship, has three layers, three levels: the national administration of justice, court management, and case management. But what is case management? We don't all agree about case management. In common law procedure, case management is much more about duration and efficiency, example about cost, sometimes about disclosure and discovery. But in France and in other civil law countries, case management, we call it mise en état in French, it is about many other things: provisional measures, investigative measures, expertise, witnesses, and so on. So it's a mix of adjudication and administration. So my hypothesis is that AI is a matter of court and case management. It's about the managerial relationship. It's not about adjudication, though it cannot characterize the facts, interpret law, and take into account emotion, and so which is necessary in the adjudicative relationship. But there is now a risk of imbalance between these both relationships, managerial relationship and adjudicative relationship. Just about emotion, I wanted just to show the picture of Leon Petraszewski, which used to be a famous scholar, stressing the importance of emotion in law and court. What is the legal framework? My previous colleague talked about it. There is the ethics chart of 2018, stressing transparency, quality, security, non-discrimination, and neutrality. But they are idealistic goals. There is a Council of Europe with a new tool of 2024, and there is this AI Act of 2024. So we know that AI in justice is a high risk, except if there is no impact on judgment. And there is no prohibition of AI which infers emotion, except for security and health. The French interpretation, which is close to the German one, as Mr. Schumann explained it, is that we need a permanent human intervention, that is in the Court of Cassation report, and not used of AI in adjudication. So we are far from the Spanish movie on artificial justice, which is quite recent. I just want to comment a little bit on the Article 6.3 of the AI Act. An AI system shall not be considered to be high risk, where it does not pose a significant risk of harm to the health, safety, or fundamental rights of natural persons, including by not materially influencing the outcome of decision making. As a result, AI is about administration of justice, but there is still a risk. What are the use cases at the present time in France? At the level of the National Administration of Justice, we have open data with very large pseudonymization of 3 million decisions, so very wide access to justice. And we decided that the profiling of judges would be prohibited by law. I suppose that it exists everywhere, but I think it's important to point out this point. At the level of court management, there is now a justice observatory to detect series, but it does not use AI at the moment, but it's a project for the future. What is present is the assignment of cases, between sections of the Court of Cassation by AI, according to the burden of each section and a very wide nomenclature. And the system said it's reliable in 90% of cases. One of the issues here, it's impossible to calculate the burden of a case for a section or a judge before the proceedings. I have to specify that the Court of Cassation report is not only on the Court of Cassation itself, but for all the civil courts in France. So this assignment is only used for the Court of Cassation, but they want to spread it to all civil court. But I think there are some risk for that. Then in case management, there is an internal database used by judges. And so they are doing case law research without AI at the moment, but it's done by lawyers, since lawyers have almost access to the same number of judgments, and now they are very powerful solution by the publishers. So there is another tool which is used by the Court of Cassation, which is a research of divergent cases. So it's connected with the case law problem. What are the divergent cases between the Court of Cassation and lower courts, and even with the open law? And the third trend is to look at the table of average damages, which are done by publisher. And so it's through lawyers that the judges has it at the moment. And there is a risk of standardization, as we know, with this kind of table. Now, what are the future? The Court of Cassation report made a list of case uses for the near future using AI to improve connexity and joinder at the level of the Court of Cassation, but in different level and a lower court as well. Dealing with pleadings and complexity, so extract information from pleadings when it's especially complex, to look for series, made a cartography of the dispute, and to look at all the legal relationship at stake, especially the substantive relationship, but the procedural as well, finding law through an internal AI system, and I'll help to write an order, even for clerk office or judgment. What is not in the report is about fact. If there is a kind of disclosure, the judge could use AI to find some information. So lawyers are using it, but it's no discussion for the judge at the moment, and nothing about jurisdiction, whereas some legal tech are doing it for parties, saying that jurisdiction is a matter of administration of justice and not of adjudication, which is not really true, it seems to me. So I would like to make some conclusion and criticism. AI is mainly about the managerial relationship. It's an help, not a competitor, no robot judge. I say exactly the same thing as my colleague, Mr. Schumann, but the AI is not neutral. The technology usually is not neutral. So for example, but it's only examples, there may be a lot of examples, to calculate the burden of different cases on judges, or to choose some series, because at the moment, series may be detected without lawyers, and there is a need to work with lawyers about series. It's a topic of pilot judgment, I would say. I would like to say that there would be a lot of time to check all what the AI is going to do. And I'm not sure that AI is going to help to gain some time. and help to favor ADR, alternative dispute resolution, whereas these arguments are in the Court of Cassation report. So we have to look at this problem of time consuming. There is a risk of standardization of judgment, not the result, which is not going to be made by AI, but standardization because it's going to be written and drafted by the assistance of AI. And I don't think it's neutral even for this point. And I would say the AI Court of Cassation report is not sufficiently general. There are many other topics which we should discuss at the moment. And so typically for France, which is a very centralized country, with a difference of, with Germany or even Switzerland, which are federal countries, is there a risk of more centralization with AI? A concentration of power for the Court of Cassation, for example. And I come back to my first hypothesis, as I wonder if there is not a risk of imbalance between adjudicative process, adjudicative relationship, and administrative relationships. So we should be careful of this development. So it's what I could present for the French situation at the moment. Thank you for your attention.
Merci beaucoup. Merci bien, Monsieur le Professeur.
Merci.
And now it's time for the regulation in Poland, the use of AI in courts in Poland. I invite Professor Piotr Rylski from the University of Warsaw and also Director of Institute of Justice. The floor is yours.
Thank you, Professor Cieślak, for giving me floor. I would like to tell you something about the current status and future development of the use of AI in courts in Poland. I think that part of my statements will be very similar to my precedents because I think that some elements are common in different countries. Of course, I think that I will focus not maybe on the current status because it does not exist in fact. I will tell you more about that for a while, but maybe more about the science fiction. It means the possibility of the development of AI in the Polish civil proceeding. In my presentation, I would like to give a brief overview of the current state. It will be two elements in my plan of my presentation. Current state and possible future developments. Firstly, current state of application. In the current state of the law in Poland, there are no explicit legal regulations on the admissibility of the use of AI instruments in civil proceedings. This is due to several reasons. The first is the lack of a clear definition of the AI for the purposes of the court proceedings. And secondly, the low degree of digitalization of court proceedings in Poland. As to the first issue, there is no clear definition of AI and its manifestations in Polish civil procedural law. As we all know, the definition itself is not entirely clear under European Union law, and the AI Act, which led the European Commission to issue in February 2025 guidelines on the definition of the artificial intelligence system established by AI Act, because it was problematic. What does it mean, artificial intelligence? Of course, traditionally and colloquially, by AI is meant the use of automated data proceedings, methods to make specific decisions. It is underlined 4 elements: reasoning, learning, planning, creativity, and pattern recognition. Other definitions present 5 main elements: simulation of human intelligence, task automatization, learning and adaptation, decisions making, data recognitions, and analysis. In doctrine and practice, realizing that AI is and what role it plays in proceedings is difficult in the absence of clear and readable boundaries for this concept. As is well known, the most questionable manifestation of the use of AI is leaving it to make binding decisions in civil cases. This is because it's a manifestation of the transfer of judicial tasks to machine, to the robot judge, as is called. However, such manifestations do not occur in Polish judicial law. The second reason I said for the current lack of clear legal regulation in the area of AI in courts is the rather low degree of digitalization of civil proceedings in Poland. So far in Poland, there is no universal electronic system for communication with the court, nor any system for conducting civil proceedings. As we know, science distinguishes between 4 levels of development and digitalization of the broader justice system, including civil proceedings. First, computerization. The second, digitalization. The third, automatization. And finally, the use of artificial intelligence in the judicial process of justice, particularly in the decision-making. Each next step should follow the previous one. In Poland, the problem is still the second step. It means digitalization. Computerization is done in the late 90s, but digitalization is really problematic issue in Polish courts. It still does not exist. A digital system exists only as far as electronic writ of payment proceedings are concerned. These proceedings have their own ICT system operated by one court in Poland called e-court. The ICT system of the e-court performs inter alia the functions of filing office, the delivery authority, repertory program, court case files, and repository storing electronic enforcement titles. This is really full electronic proceedings, but it's not mandatory and it's only partially proceedings because concern only admonition or writ of payment proceedings. The second fully digitalized proceedings is the registration proceedings for entry into the register of entrepreneurs. And that's all, in fact, and that's all. As is well known, the condition of the use of AI in civil proceedings, it is digitalization. It means the possibility of collecting data in electronic form. We cannot develop AI mechanism without digitalization. Meanwhile, in Poland, still 90% of procedural actions are performed in traditional paper form. This hinders the development of the use of AI instruments in court proceedings. It seems that the key to the introduction of further IT solutions in the courts must be the direction of digitalization of the case files of the proceedings and enabling access to them by both court employees, including judges, assessors, registrars, deciding the case, and the parties to the proceedings, as well as other interested persons like court experts. Such a change in the form of keeping court files would ensure the flow of information about the proceedings between the interested parties in real time. It should be pointed out that keeping them in the current form as paper files closes the possibility for further development of electronic means to further automate court processes. The lack of explicit regulation of automated decision-making also manifests itself in the failure to use solutions that operate at the level of the EU law. For example, an explicit legal basis for the use of automated data processing is contained in Regulation 1896 of 2006 on the European Parliament creating a European order for payment procedure. We know that it's obvious that according to recital 11 of this regulation, the proceedings should use the automated data proceedings. The same is in the Article 8 of this regulation. But the Polish legislator, in the provisions introducing the European order procedure, did not introduce the possibility of using an automated procedure. Thus, it acted differently from, for example, the German legislator who enabled the use of an automated procedure for issuing such orders in the elektronische Mahnverfahren proceedings. Yeah? So the Polish legislator, despite of the discussion of this issue in the doctrine, has not decided on similar legal regulations. Now I move to the further development, because present state of affairs, you see, is is like that. So we've got the problem with digitalization even when we should think about development of AI. Each of us intuitively senses that the role of the AI in court proceedings will grow. However, it is not possible in the long term to predict changes with certainty and clarity, as technological progress is very fast and probably absolutely unpredictable today. The doctrine considers two models for the future use of artificial intelligence in Polish court. It means, first, a model of full and autonomous use of AI and advisory model. In the case of the first model, the most complete, it is assumed that artificial intelligence techniques would be applied to create a system that would be authorized to conduct court proceedings on its own instead of the judge. But we know that this model is rejected by the AI Act, and I will not develop this model. I think that nobody thinks about this model in this moment in the European Union. Therefore, a second model for the use of artificial intelligence in the administration of justice is possible to consider, which does not aim to replace the human being, judge or court registrar, but to support him or her, thus adopting an advisory model based on automatization and artificial intelligence. Depending on the category of cases, this model could more broadly take the form of an AI-based support system performing an initial analysis of the case, the end result of which would be to make a proposal to the judge for the outcome of the case and requiring the final approval of the decision by a human. The model could also take a narrower form. It means quite supportive, supporting the human conduct of the proceedings and analysis of the material, but not proposing an adjudication, but only aiming to streamline the proceedings and the analysis of the data. What are the areas where this model could be applied? I think that there are two main areas. First, institutional and organizational issues. The second, procedural issues. What about institutional and organizational issues? Among the institutional issues, one should point out the assistance of the AI tools in the management of judicial resources. This refers, for example, to the creation of instruments for monitoring the state of the caseload of courts and proposing etatization, it means staffing of individual courts in Poland. It is possible to assist in the management of cases and their number with a view of efficient allocation of cases between courts and individual judges. This would involve the creation of measures of efficiency and workload for judges, for registrars. The use of AI in the daily practice of judges and lawyers should be, of course, obviously considered. This includes, for example, software for drafting pleadings and court motivations, which are probably already being used to some extent. Today, we do not know. A couple days ago, National Bar Association of Attorney at Law adopted recommendations for lawyers about using of AI in their practice. Okay, it's the try of the soft law, introducing soft law, what should be done, what should not be done in the practice of lawyers. We do not know what is the reality in fact. Officially, it's not regulated in provisions of Polish law, only in the ethics or codes of ethics. The use of AI systems should be developed in the performance of various activities of the technical nature, such as transcription of court hearings from e-protocols or translation from a foreign language. But I think that this is only institutional and organizational issues. But what is much more important, this is the problem of using AI to the procedural issues. I would like to mention maybe about two examples. There are, I think, mainly two areas for the possible development of AI in this advisory model. First concern the crucial element of the proceedings, which is the evidentiary proceedings. The second concern adjudication of cases in the repetitive and mass cases. Evidentiary proceedings. Firstly, one can envisage the possibility of using instruments that enable the collection and rapid analysis of data available on the internet and public registers. This involves the possibility for the court to use facts that are generally commonly known. According to Article 228 of the Polish CCP, as in many other countries, the court should apply ex officio facts which are commonly known, or in Poland, facts known ex officio, or facts that are generally available. So this software could help the court to search some information from the internet or registers and to apply that to the case. Secondly, it seems necessary in the future for the courts to use deepfake detection software. This is now, I think, still a growing problem, as it's well known generative AI tools offer the possibility of creating or influencing the content of material that can be the subject of evidence in court proceedings. AI tools are already widely and often freely available today that can potentially, for example, generate documents imitating authentic documents, generate photographs depicting real people in false situations, clone the voice, create sound recordings, etc., etc. Even they use deepfake technology both to create videos facially depicting someone's behavior and to impersonate a witness, party, or attorney. And that's why the court should apply some software to fight with such deepfakes. It means to find where is the deepfake and to control the proofs and evidences which are presented by the parties. But this example indicated leads to serious issues that will need to be addressed and solved under the principles of civil procedure. For example, whether the use of deepfake detection tools by the court should change the rules governing evidence proceedings. For example, the adversarial principle. If the opposing party does not question the credibility of the evidence presented, the court's action ex officio should be limited. It's not should be done in every case, for example, to verify presented evidences via such special software. The question also arises as to whether the court should not, in such a case, use an expert opinion rather than resort to application of special software. What does it mean? This is the special knowledge, the finding what is the deepfake in the case files. And the second issue, settlement of repetitive or mass cases. The advisory model for the application of AI could apply primarily to civil cases, such as payment cases heard, for example, in the European Order for Payment Procedure or according to national provisions of the CCP in order for payment and writ of payment proceedings, or certain categories of, for example, repetitive matter like succession cases, proceedings to establish the acquisition of an estate. Consideration should be given to the potential use of the new technologies in injunctive writ of payment proceedings, in particular as regards the potential involvement in assessing the grounds for issuing an order of payment, both methods in Poland, both tracks, it means injunctive and writ of payment proceedings, and formulating a proposal for substantive rulings, which would require the approval of the human decision maker, because the finally should be the decision of the human being. However, as it has already been mentioned, full digitalization of Polish civil proceedings is necessary. In the case of development of a court system enabling the communication between the parties and the procedural authority electronically, and conducting the proceedings in a digital form, it means possibility to file a statement of claim and other pleadings together with attachments, evidences in an electronic form, at the same time allowing to file a letter in traditional paper form should be done. So to sum up, to summarize the consideration so far, the legislator faces a daunting task in formulating a legal definition of artificial intelligence. It should meet the objectives of the European AI Act, of course. It is questionable whether there is a need to define this concept for the purposes of civil proceedings only, maybe for the judiciary, for judicial system generally. However, it is necessary to further digitize civil proceedings in Poland, as without this, the use of AI will be more theory than practice. And of course, it will be only done without explain regulations, and I think it was, because the technology will develop without regulation from point of view the legislator. It's not a good way. And this model for the development of AI in civil proceedings, where it will be advisory and supportive rather than decision-making, should be strongly supported. The main areas for the application of AI in the advisory model are, as I said, court administration and procedural actions, as well as the area of evidence and assistance in the adjudication of repetitive and mass cases. So, thank you very much.
Mr. Professor, thank you very much for your report. According to the schedule, there is no discussion at this moment. There's time for coffee break, but before it, I will only present short comment on the chat. This is a comment, not a question. The research on legal, including in judicial applications of AI, has a long history too. It was started in the 1970s in the United States. Okay, so now we start the second part of panel 2. And the first speaker in this section is Professor Irina Izarova, and this report connects the regulation in Ukraine. The floor is yours. Thanks.
Thank you very much. Thank you very much. Yeah, that's fine. Thank you for inviting me. I enjoy this conference very much. The first panel was absolutely amazing, and I thank my colleague, Professor Andrzej, for his concluding remarks about court management, because my speech actually more about court management than about concentration of facts and evidence. And I hope some of our recommendations or insights will be helpful to organize the system efficiently. You are absolutely rightly mentioned that we can polish rules endless, but it depends on how to implement it, who implemented these rules. My speech was prepared initially, planned to present with my head of department, Professor Oksana Khatynska-Nur, who unfortunately could not attend today, but I hope we will soon come together with her. And so that's not the first slide, actually. Yeah. So you can see on the slide the interactive map of court network in Ukraine, and this issue is absolutely urgent and extremely important. It became more complex in the context of our EU integration and accession negotiations. However, this problem exists as a serious problem even before that. I will briefly illustrate it with some examples. The first one is workload. Workload, of course, is one of the main problems in Ukraine. So some judges in Ukraine handles 400 cases per year. Some other judges handle 4,000 cases per year. This absolutely affects the quality of judges and public trust in the judiciary. We faced with incredible staff increases in Ukraine. In many local courts, the number of judges is formally 3 or 4 persons or 5 persons, and they cannot function properly. One judge may lack of power due to expiring appointment, another is on long sick leave, and another prepares for retirement. So as a result, we have one judge in one court. At the end of 2022, we had only 4,400 active judges out of 6,200 positions. So 1/3 of the total number of judges are vacant in Ukraine. This leads to excessive workload, delays, inability to form panels, and other problems. European Court of Human Rights, as usual, mentioning about growing number of applications against Ukraine related to violations of reasonable time requirement under the Article 6, and since 21 to 24, almost 200 of cases with such violence by Ukraine due to excessive length of judicial proceedings. Like an idealistic decision for solving this, a lot of issues, optimization of court network was proposed, and Council of Judges emphasized efficiency with limited resources during wartime. Optimization, it's not only downsizing of courts, but improving performance of justice in these courts. We had a few reforms since Ukraine restored our independence more than 30 years ago. And this network of courts was updated. The last reform was in 2017-2018. As I said previously, that was a great procedural and reform with a lot of consequences on different levels, and that was on the way to Europeanization of procedural law and enforcement in Ukraine and justice in general. But as in community of judges, opinions rise about lack of reasonable criteria behind court reorganization, lack of formal understanding of why such reorganization of courts were proposed and partly implemented. In addition, in 2020, in Ukraine, territorial reform changed the meaning of administrative territorial of particular regions. So that was done by parliament, and due to this reorganization, many of just ordinary courts of first instance fall outside the new administrative districts in Ukraine. It created quite a high level of legal uncertainty about jurisdiction of courts. In 2024, just a few months ago, the idea of creation something like a national court directory was proposed, because not only ordinary citizens are not aware about territorial jurisdiction of some courts, but some judges as well. It's hard to imagine, but it could happen. So we are living under a new territorial system since 2020. But courts, to transform courts network, it's not so easy and not so it's not very easy, and it should be very important state to reorganize. So that was done by our official state court administration. And that's like a possible option for showing the size and the numbers of cases, of judges, of case handling standards. But first of all, it doesn't work properly, so it's not interactive, even if you try to click it. We put a QR code for those who want to try. But in general, it's very important not only to share this data, but also to give possible options for researchers, for lawyers, for judges in some kind, to try to use this data for their own like everyday work or their own goals. So I would like to draw your attention to the possibility of visualization of data that openly available from courts administration, and how we can use it for our research, for monitoring of functioning of judiciary on national level, as well as we have I can share some interim results. We have like possible recommendations for policymakers for further optimization of judiciary. So that's one of my beloved map. You can see it's one of the very famous and resonance courts in Ukraine, administrative courts. If some of you have ever heard about Ukrainian judiciary, I swear that it's about administrative courts or about our constitutional court. So we, for this particular meeting, we prepare a few maps with this administrative appellate courts. On this map, you can see administrative circuits with appellate courts and with territorial distance for getting by car from particular regions of Ukraine, and that's very small limits of particular regions. So you can see quite a lot of different regions are not even in 1 hour distance from this court. In general, we have in Ukrainian judiciary includes over 700 local courts, local and appeal courts. We have more or less approximately 7,000 judges and more than 20,000 court staff. And it's important to ensure that just a few more words about courts. From 600 functioning courts, we have 87 courts are not operating due to hostilities or occupation. In an additional 84 courts have not functioned since 2014, including those in Crimea and part of Donetsk and Lugansk regions that were occupied. 86 court buildings have been damaged to varying degrees. Kharkiv, Donetsk, Luhansk, Kherson, and other regions. So, in addition, territorial jurisdiction of around 170 courts was changed according to the current situation on the east border of Ukraine. But in general, we have quite a stable number of cases every year, more than 4 million cases, and we have an openly available register with more than 100 million documents in National Court Register. So mapping of court data, it's not just a tool, it's like strategic necessity for us, because it helps to identify overloads, gaps. Like here you can see quite a huge gaps in a very simple accessibility of courts of appeal. It shows isochron. So, of course, the best access in Kiev, that's 6 court of appeal. 50% of population have better access to court, and the lowest access in Donetsk court, only 10% of persons, and quite a low access in Lviv and Vinnytsia. That's west part of Ukraine, 2 courts. We're talking about 15% of the total population who are able to access this court during 1 hour by car. Yeah, so I hope this is this particular card with distribution of lawyers among these courts, and we can show the ratio of population to judge, because as you can see by intensive color, there are very like more populated territorial of Ukraine than other. For instance, of course, east part is much more populated, as well as the central part with Kiev, around the capital of Ukraine. And we can see distribution of judges and case inflow per region. Some like very general remarks about that goes to the capital as well, and to Donetsk, because it's consistently understaffed and needs some more support. And south part of Ukraine and Vinnytsia region shows like relevant balance. We have also indexes of resolved cases, and compare the number of resolved cases and number of judges for better understanding workload and potential burnout, like for instance as well Kiev and Donetsk, but here we can see also Lviv region because of perhaps more internally displaced persons who moved there, so let's mismatch some results. Here is the budget and case resolution. Of course, it's very important how to distribute budget, and some of my colleagues immediately admit that in 2019, the previous president gives more money to his original regions than it was expected, and we can see like expenses growth, but results case dropped in this region. So some of these findings should possibly marked that guide budget allocation and system required more optimization. It's quite a long story. This last slide shows indexes of various types, because structured data allows us to compare different things in many ways. So you can result something like population density index and compare it with judicial staffing index, activities, and funding efficiency index. For instance, it was proposed by one of my colleagues how to evaluate result cases per funding per one person of judge staff. And we can see, for instance, from this perspective that Kiev court ranks highest in all indexes, but shows over centralization. And Donetsk regional court ranks lowest, reflects partial dysfunction, which is comparably expected from us, but anyway, we can see right now more clear what could be the possible ways of optimization. And it was very interesting really to to monitor Lviv and Vinnytsia regions, because sometimes it moderately actively, but sometimes underfunded for specific years. Of course, these indexes help move from subjective to evidence-based decisions, and it should help to support planning, budgeting, competition design. We can start mapping high-profile court, especially very numbered of courts, like courts of first instances in Ukraine, which right now consist of 673 courts. And also we're planning to supplement this data with number of attorneys in particular regions, especially free legal aid, which is absolutely necessary and important for us. And it's key points for access to justice, equal access to justice, as well enforcement officers and other stakeholders. I hope that after my presentation, Judiciary of Ukraine did not looks like this very famous painting from Michelangelo, but I expect that altogether we will make it better, just focusing on collecting more data available in open access, because right now we are talking about years of before war in Ukraine, and we're still, due to some ethical considerations, not include this period of time of war in our methodological frames of this project as well. I would say some collaboration between judiciary and other branches of state power would be very necessary, because this problem of administrative territorial jurisdiction could be resolved only in this way. Yeah, thank you very much.
Thank you, Mrs. Professor. And now I invite Dr. Florina Morozan from the University of Oradea, and the report is about the situation in Romania. The floor is yours.
I also have a PowerPoint presentation. Thank you. It's not so beautiful like Irina's presentation. Thank you. I have a... So this is forward and backward. Okay, thank you. I will try to speak to the microphone. I usually speak so loud that I don't need it. We are talking about the current status and future development and the use of AI in courts in Romania. How is this? It's good? It's good. It does not change, only here.
It works.
Okay. Yes, I had the feeling that I will see there, but it's different. Okay. As you see, why it's necessary to talk. We talk about AI, but I think we have to start with digitalization, as our former colleague who was the moderator, our colleague from Warsaw, told us, and also Professor Schumann. I see that we have some common problems, but also I can understand that we are not starting from the same position. Maybe they are starting from pole position to make a compare, not in Romania. Because now, only now, we are witnessing a broad reform in the judicial system to digitize and integrate artificial intelligence into the activity of the courts. But this reform was necessary because it was lagging behind. Thus, in a report published by the European Commission in 2019, Romania ranked last in digitalization with a score, DESI score, Digital Economy and Society Index, of 33% compared to Denmark, with a score of an aggregated score of 70%. So we were behind and we had a lot of things to do. The low score is also explained by a weaker digitalization at the level of the companies and also of public authorities and institutions compared with EU states. As I saw in other countries, also in Romania, I may say that artificial intelligence does not contribute to the decision-making process, even for cases with a minor impact. We use AI, we implemented AI, and for the purpose to develop and increase the accessibility of judicial system and to reduce the average duration of case resolution without, however, leading to a decrease of quality. Some colleague asked me, you asked me, what about COVID? If COVID had any effect? Yes, I may say that COVID had an effect because courts were forced to focus on digitalization in order to minimize contact with litigants, the electronic communication of procedural documents, and the possibility of judging some trial remotely were established as a rule. What is important that after that, we saw that the temporary measures applicable during the state of alert declared in order to prevent and combat the effect of COVID have proven to be beneficial. They achieved their objective by streamlining procedures and simplifying the ways to realize the rights of citizens and legal entities. Therefore, it was considered that they can further facilitate the easier and faster conduct of legal procedure. Consequently, Law 220 from 2022 was adopted, and this law was the first step toward expanding the digitalization process at the level of the court. The law regulated the possibility of temporary application or, as the case may be, the adaptation of measures established during the state of alert declared in order to prevent and combat the effect of COVID-19 pandemic. According to this law, courts may decide that court hearing be held through audiovisual telecommunication means that allow to verify the identity of the parties and guarantee the security, confidentiality, and quality of transmission. Also, at the request of the court entrusted with resolving the trial, the court in whose jurisdiction the parties are located shall provide, with the parties' consent, the audio-video equipment necessary to their participation in the court hearing. Public court hearing also may be broadcast and are broadcast live through audio-video means that guarantee the security, integrity, and quality of transmission on the court portal. we should mention that this measure was unfortunately only temporary. They were applicable for a period, only for a period of 1 year from the data that the law entered into force in the period 2022-2023. About the further regulation, subsequent regulation, we must say that we had some steps, some small steps, but in the same direction. One step was a decision of the Romanian Constitutional Court. As I told to a colleague in the break, we have, unfortunately, we have numerous Constitutional Court decisions which modified the civil proceeding. Not only Constitutional Court, but also decision of the High Court of Justice and Cassation from Romania. So in a decision from 2022, communication by electronic mail as a main way of communication of procedural document without being conditioned to carry out the procedure in paper format was allowed. The court considered that it's okay to communicate, it's legal to communicate only by electronic email. After that, our code was modified in 2022, and it provided that the communication of court decision will be made by electronic mail if the party indicate the appropriate data to the court. Those were two small steps. About the digitalization, I must say also that we have an internal rule, a document, the internal law, the internal rules of court, approved in 2022, which allows and says that we have to record in the register of each court in computerized format. At the end of each working day, the database will be secured by saving it on an external medium in accordance with the operating instruction of the computerized database. You may see two other two important law. We have now, from 2023, we have a Romanian Committee for Artificial Intelligence, and from 2024, we have a national strategy in the field of artificial intelligence, a general strategy, not only in law. You may see there the general and specific objective of this national strategy. In the sphere of the benefits of using AI, our strategy highlights, by way of example, for the perspective of the areas of applicability, the extent of the impact that technology can have in increasing the quality of life of citizens and development of society. This strategy was adopted then in 2024 according to the regulation, to the European regulation. So it respects, as it's normal, the European regulation. After that, I want to talk you, I told you that digitalization and AI in Romania, it's interesting in court management, in case management, in court administration. That's why I want to talk to you about a few portals and applications that courts use. One application, I know that it's used in other countries also, it's ECRIS, Electronic Court Register Information System, is the most important for the court clerk, for judges. The platform is accessible to judges, clerk, as well as parties or their representative in cases where they are directly, that directly concern them and under certain condition. ECRIS performed the automatic and random distribution of cases on panels of judges and stores data on the files from the beginning to the end of each judicial procedure. We also have Statis ECRIS based on ECRIS, which stores and processes data that can generate reports on the complexity of the case, the stage of resolving the case, the selection of cases according to subject matter. And in Statis ECRIS, which is essentially a quantitative efficiency measurement program, Statis ECRIS stores and processes data, generating reports on the statistical efficiency indicators of the court and each judge. In this computer application, there are algorithms that help clerk in managing cases, avoiding wasting time on repetitive tasks. What is very important when we talk about AI, we must say that courts in Romania use AI to sort, to process, and to upload documents submitted by the party. Scanned documents submitted by the party or received by the court, they are sorted and processed using robots and automatically uploaded to the court's database, creating the corresponding entry. Robots replace the work of 2 or 3 employees in each court. They process, we had a statistic a few years ago, they process 2 million documents per month, maybe nowadays more. The application is used by all courts in Romania. 16 copies were installed in all courts of appeal. The application integrates an image processing neural network based on the latest model in the field, which classified between summonses, proofs of delivery of documents, proofs of publication and other documents, and delivered them to the correct robot for processing. The application and robots update themselves without user intervention. Robot doc, it's a robot that uploads documents scanned by the users, archives, registry, or court clerks directly into the court system, into ECRIS. And from there to the electronic case file, I will talk also about the electronic case file. The application can be used regardless of whether multiple documents are scanned to the same case file on the same days, does not require folders to be completing that task. Over the time, ECRIS has been modernized through several versions. It is the most, as I told you, it is the most important instrument for the courts and the clerks. ECRIS generates scheduling, generates personal registers, important aspect of case file, including objection, evidence, the party that proposed them, whether they were discussed, whether the judge ruled them, general observation, and this information is also available for later consultation. It generates templates, easily create documents that can be reused by taking all necessary information from ECRIS, generate electronic files, and generate judges' resolution directly from the web application and easily calculate the stamp duty, the generated resolution being saved in ECRIS. Also, it has it's setting trial deadlines, it has session recorder, You may see here one. This is ECRIS for the court. Here we have the solution of the court. You may see the number of the document, the data of the document, the delay, the reason of the delay, if is a delay in the solution. We have all kind of interfaces for the judge, for the court clerks. It's really, really useful for the court. ECRIS database can be accessed through the portal of the Ministry of Justice. Each court has its own website, and information about files and hearings are automatically updated daily at the central level. What you can see is the portal, which is also based on ECRIS, which is available for each citizen. It contains only general information about the case. Not all the cases are on the portal. You cannot find out information, for example, about a divorce, because they are personal cases and they are restricted. But I can find general information about a case. Sorry, I isolate that it's a criminal case, not a civil case, but it's the same in the civil case. You can see who is in that file. Then you may find, if you know the name of the citizen, you may find the number of the case, what happened in the case, when it will be, when is scheduled the next hearing, and the solution also. If it has a solution already, you also see a short solution. So it's extremely useful for us. But ECRIS was the first. Now we have other instruments that are more useful for the citizens and the practitioners. One of them is the electronic case file, an IT application created through the own effort of some court. It's the independent effort of Arad Tribunal, Cluj Court of Appeal, and after that, those applications which has been so successful, they have been taken over and implemented by many courts in the country. The electronic file allows judges, parties, lawyers access to the document in the file in electronic data by using a password assigned for this purpose by the court under data security condition. For me as an attorney, for example, I receive a password each time when I want to access the file through my email. They need your phone number and your email to identify you. It's not the only application which is useful. About this file and the application, I must say that an important Syria artificial intelligence program, neural network models, was designed and developed at Galați Court of Appeal and then extended to the Court of Appeal in the country. We have also a portal of High Court of Cassation and Justice. I didn't take a picture about him, but I have another, it's the last, another application what is extremely, this is the file, the electronic file. We have a picture, so you have to ask access to the file, you receive the password, and after you receive the password, you may access your file, and it appears in this way. You have all the documents from the file, and you may access them, and you may download all the documents. So as a practitioner, it's very easy. If tomorrow I have hearings, I know exactly if are some new evidence in the case or not, and I know exactly what I have to do. Another application, it's the case law portal, another portal, it's a portal, which is also useful. It was designed and developed by the Superior Council of Magistracy to allow citizens and practitioners easier access to the court decisions issued by national court. Initially, it was developed by Galați, as I told you, and later it was expanded nationally. The portal was launched in 2021. Citizens have easy access to court decisions issued by national court. To ensure permanent updating of case law within the portal, courts are obliged to ensure the uninterrupted connection between their own database and the data center of Superior Council of Magistracy. We have important elements that assure the the protection of personal data, because this is a problem in those those judgment, the solution that in the past we had all kind of programs, and you easily may identify the part and the case, even if you had only the case number. That's why for protection of personal data, anonymization criteria are established for both personal data and the file number, as well as any data that may lead to the identification of the file. Among the documents registered on the portal, some are excluded from display based on objective exclusion criteria. We have a list of excluded cases which are excluded from that. I must say also that Rejust is useful also for paying the debt what you have, and you may use also to communicate some documents on electronic way. So it's not only just a case law portal, even if I speak about this more. It's more useful, and also that application of the of our High Court of Cassation and Justice allows to upload documents to a case in an electronical way, and it's not necessary, as I told you before, it's not necessary to bring the paper documents also. This is how it looks, the Rejust. So you have all kind of criteria you can select to find some judgment, anonymized as I told you, and it has a special number, that judgment, which allows to identify later on the portal. So if I want to refer to a case before a judge, for example, in a case, then I must refer to that number, and the judge may search if it's really a decision. And I have to say that Rejust, it's anonymized only for the citizens and the practitioner. It's not anonymized for the judge. So the judge has all the details he considers necessary to use that decision as a base of his future decision. So I can say this is the possibility to pay that, or if you want to start a new case, have the possibility, or to want to add some document in an existing case, you have the possibility. I think it's quite friendly as it looks and easy to use for each citizen. I hope that what I told you before proved you that we are making steps, small steps, with more or less success. Rejust, for example, is very useful. The electronic case file is extraordinarily useful for a lawyer, a practitioner. It's useful for each citizen who is interested in some case. We can see that digitalization and AI, where we use AI, facilitate the work, of course, increase the quality of act of justice, and they assist judges in carrying out administrative tasks or repetitively time-consuming tasks, so they have more time to focus on other tasks, more judicial, to say so. Also for the practitioner, for the citizens, they are very useful tools which ensure the real access to justice, to a modern justice. Of course, we have a risk also, and when you talk about digitalization or you talk about AI, the main risk is the security of the connection. For example, ECRIS, in the past, each court has had its own database, and a judge from another court could access that database, but we hadn't a central control. Now they are centralized, all the databases, which increase the risk of security. This is one problem. The other connected to this is the data confidentiality risk, and also the lack of transparency of AI systems regarding the way certain decisions are made. As our colleague specialized in AI told us, we don't know always how he thinks, how he takes one decision. And finally, one colleague from an informatics faculty told me that he noticed that AI is very attractive. It's easy to fall in the trap, but when you use too much AI, you become sillier because you don't use your brain. And I think this is a risk for all of us. Thank you for your attention.
Thank you, Doctor, for your presentation. Yes, excessive reliance on artificial intelligence can lead to cognitive atrophy. Yes, that's right. And this is the disadvantage connected with artificial intelligence. And now, last report, last but not least, I would like to invite Dr. Maciej Durbas. Dr. Maciej Durbas from Jagiellonian University and also from Legal Kubas Kos-Gałkowski. And the report is about the use of artificial intelligence by arbitral tribunals.
Good afternoon. Let's wait for my presentation to be there. The last one, yeah. Seems it works. Good afternoon, everyone, and thank you very much for having invited me to this very interesting conference. And I have a very tough work to do because I'm the last person standing before a very interesting discussion and, more importantly, a glass of wine or other beverage of your preference. So let me be very brief. I will discuss today the use of AI and future developments by arbitral tribunals within the, let's say, private administration of justice. And the starting point is everyone is using AI everywhere in every capacity. Last week, a client of mine asked me a question based on AI. Why I knew that? Because I asked the client. Well, the question was quite bizarre. I was totally taken aback. Never heard of such an institution. So I said, okay, I have to research that and come back to you. And I came back and said, listen, like, can you be frank? Is it an AI-generated question? Yes, it was. Complete hallucination. As an arbitrator, I received a witness statement generated by AI, the template, I mean. The template, why I knew that? Because it contained provisions from a code of criminal procedure in Poland and perhaps in other non-existent jurisdictions. So it's there, everywhere. Every week, every day, we face it. So AI can also, if we face it as arbitrators, AI can also help us. Can it and should it? Well, of course. It has to. I totally concur with very interesting interventions from Austria, France, Romania. AI should help us in administration of justice, not adjudication. And I want to use a very interesting quote by a Polish graphic designer, Joanna Maciejewska. She said some time ago, with reference to AI, that she wants the AI to do her dishes and laundry so that she can do her art and writing and not the other way around. So we all want, as lawyers, judges, arbitrators, for the AI to do the laundry and dishes in dispute resolution so that we can do our art and craft, meaning advocacy, adjudication, etc. So this can be an ideal world. This can go right. What happens if it goes wrong? 2 weeks ago, this is a filing in US court proceedings from 15 May 2025. This is a case between a major music companies in US against a company that runs one of the most popular AI chatbots. And the lawyers representing the defendants, so the AI company, were very unfortunate to use this very chatbot to generate quotations for their briefs. And unfortunately, they made some mistakes. And these mistakes were spotted by, I'm not sure, the judge or the other party, and they asked for some clarifications. And this is the response by one of the lawyers. If I'm not mistaken, this at least has been the biggest law firm in the world. And they say that basically they use the AI only to just enhance the citation to help. Unfortunately, the citation missed the errors. And it meant that they did a very embarrassing and unintentional mistake. Basically, this this document serves as their defense from relying on fabricated legal citations, which is a very serious problem for a lawyer in US, because they can be held contempt of court. So this can go wrong. So what to do to avoid it? Well, the current legal framework, hard law, is virtually not existent. We refer to EU AI Act, but the most prominent worldwide legislation for arbitration, the New York Convention, does not refer to AI. Unsurprisingly, it's from 1958, but it does refer to very modern technology as the telegram. Not computer, not any other, but the telegram itself. Well, domestic laws are not helpful as well. Well, we are not sure whether an arbitral award has to be generated by human or not. Laws differs and opinions differs on that matter. So yes, we should rely and have a look what the AI Act says about the use of AI in dispute resolution. But before we go there, I want to compare two approaches. EU approach wants to reconcile innovation with EU approach to values, human rights, whereas we have a completely different approach in the US that is fragmented, sector-based, and very focused on innovation. Which approach will be more prominent, we will see, but based on the companies we'll see that are rivaling, probably the second one. A first question, are arbitrators, does the EU AI Act apply to arbitrators? Well, of course it does. It has the EU Act has a very broad definition of deployers. Where if a natural person or a body uses AI in the scope of their authority, they are deployers. But it also means that an arbitral institution and other stakeholder, arbitral secretary, can be also a deployer of AI system. And EU, as you probably know, labels different kinds of legal systems, and the most important, apart from prohibited, let's leave it aside, are the high-risk systems. We've already heard today, but I want to focus a bit more on whether this is a high-risk system or not, if it's used by arbitrators. Well, the rule is that if it's used in the administration of justice, also in the alternative dispute resolution, this is a high-risk system. But there is an exception. If the system does not, I quote, materially influence the outcome of decision-making, it is not a high-risk system. What does materially influencing mean? We don't know yet. There is no case law, no guidance. We will see how it develops. But we can, I think, make a safe assumption that if arbitrators are merely assisted by AI, most probably they won't be labeled as using high-risk systems. It is natural for arbitration law to fill the gaps where the hard law is not existent by soft law. And fortunately, there are at least few initiatives by different bodies to make sets of guidelines that would apply to use of AI in arbitration. The Silicon Valley Arbitration and Mediation, certain guidelines from last year. The SCC, Stockholm Arbitration Center, AI Guide, and from March 2025, the Chartered Institute of Arbitrators from London, AI Guideline. Well, the hierarchy of the guidelines being comprehensive is precisely such. So the CARB, the latest, is the most comprehensive. However, I must say that I am a bit disappointed with the soft law developed yet to date, because it does not give us any answers. It encourages to do some things like disclose. They rely on very general, broad terms that we can all agree with, like be transparent, preserve party autonomy. Well, of course we'll do that, but we need a clearer guidance what to do or what not to do in arbitration. And the last initiative, the IBA, known for a very comprehensive sets of standards for impartiality and independence of arbitrators and rules for evidence proceedings, might be this initiative that sheds some light on the gray zone, which I think will be very welcomed by practitioners in arbitration. I won't focus a lot on practices in domestic courts worldwide, but again, a very general statements that everyone can agree with. Be transparent, always as a judge, be responsible for AI-generated results. AI should always be a support tool, not a replacement. And coming to the gist of the matter, so practices of examples of AI used by arbitrators, I was asked by one of the colleagues whether there are any empirical researches about the use. I'm afraid I don't know of any comprehensive researches, but I have attended a lecture by a very prominent arbitrator who said that, well, I wanted to be a very tech savvy, and I invited the members of my tribunal to very prominent law firms to include a provision on the use of AI in the procedure order number 1, so the framework for the proceedings, and leave the decision to the parties whether we as arbitrators can use it or not. And what the parties did? They deleted the whole provision. Does it mean that the parties don't care? Well, I'm close to that opinion. Well, I believe that the parties do not care what the arbitrators do as long as the justice is delivered. And we see here that arbitrators can do a lot of activities that, according to the definition we just given a couple of minutes ago, might not materially influence the decision making. Some legal research, some drafting documents, proofreading, some reviews and translations. And these examples that come from the SCC guide I referred a couple of minutes ago are usually labeled by authors that write about AI in arbitration as not materially influencing arbitrators. Whereas if AI is used to predict the outcome of the dispute or some assistance in decision making, then yes, it materially influences the arbitrators. But I think it actually misses the point because, well, if we ask the AI to do a summary of parties' position, and we don't fact check and we don't rely on it, it may materially influence our decision because we can omit a very important argument brought by the parties. And to the contrary, if we ask the AI to write a very small portion of an award based on a very precise prompt and the direction showing our approach to a given legal problem, well, I will defend the opinion that this does not at all influence the decision making. So we, meaning I'm doing research on AI in arbitration with a colleague from Erasmus University in Rotterdam, Dr. Piotr Wieliński. In our recent article, we proposed a test that whether if the arbitrator thoroughly reviews the work, verifies the AI assistant, fact checks, and conduct their legal research, it means that there is no material influence on decision making, whatever activity they are applying in arbitration. What is also important is that a lot of hype and buzz in arbitration is about parties' consent and information to the parties. And the soft law I referred to also encourages disclosure, encourages information. But if we have a look on the EU AI Act, only if a system is high risk, then the deployer must disclose its use. But if we stay within the limit of not materially being influenced by AI, we're not in the sphere of high risk. So we don't have a legal obligation to disclose the use of AI. And EU AI Act does not operate on the presumption of a consent. So no consent is required from the stakeholders to the deployers. So unless there is a very clear agreement between the parties and arbitrators in the matter of procedure order number 1, terms of reference, when the hard law and soft law do not provide for consent or information-related obligations, they are most likely no such obligations to the arbitrators. Arbitrators, which is a very peculiar thing in arbitration, might be challenged for the lack of independence or impartiality. And the question arises whether the use of AI might be, or misuse of AI might be the basis of such challenge. Well, if we look at the definition of dependence and partiality, we're most likely not, because impartiality refers to bias. So if we use technology, whether it's LexisNexis, Westlaw, word processing documents, we are biased or not biased at the same degree we are using other technology. So our proposal is that arbitrators cannot be labeled as partial merely because they use AI. And I'm leaving here aside the question whether a given chatbot, given AI software is biased or not, because we've heard at the beginning of the discussion they probably are, because we are all biased. But there are some arbitral rules that offer broader scope, broader grounds for challenge. And an example here, ICC rules. An arbitrator might be challenged for the lack of impartiality, independence, or otherwise. What does it mean, or otherwise? Where the practice of the ICC Court of Arbitrators shows that this provision has been relied when the arbitrator was absent, not answering emails, not there for the hearing, or misbehaving, meaning quarreling with other arbitrators or parties. So our proposal is that, yes, in some cases, the misuse of AI can be a ground for challenge. Two conditions. First, if a given set of arbitral rules, the arbitral law here, offers a broader grounds for challenge as ICC rules. And second, if there is a complete delegation of decision-making to AI. So if we see that we don't have an arbitrator, we just have a person that talks with AI chatbot and produces some words to us, it can be a reason for challenge them. And another question, final question here, is whether misuse of AI can be a reason for challenges to arbitral awards. And we want to make a comparison here to the very known and very well thought problem of the use of arbitral secretaries in arbitration. You're maybe familiar with the UCOS case, a very important arbitration case between the former shareholders of UCOS and Russian Federation. The shareholders won a multi-billion award in arbitration from Russian Federation, and Russian Federation moved to set aside the award, and one of their arguments was that the award in most part was not written by arbitrators but by the arbitral secretary. And in order to prove that, they showed a forensic report based on legal writings on this given person, and showing how similar the writing style is in the works and in the arbitral award. This argument failed. This argument failed because there is a presumption, and it's confirmed in more and more cases, then, well, if the mere fact of reliance on arbitral secretaries is not enough. Because there is a presumption that if an arbitrator signs the award, it accepts it in full, the full reasoning. So it's his or her award. irrespective of actually who has written the exact wording. And actually, this rationale is close to my understanding of the use of AI. So the mere fact that AI assists in decision making, well, the drafting assistance, the mere use would probably be unlikely to trigger a successful challenge to arbitral award. But if we go deeper, there are more risks for arbitrators. So legal and factual assistance. Well, if an arbitrator, coming back to the definition of materially influencing, if an arbitrator does legal and factual analysis that goes beyond the party's position and goes beyond the facts of the case, they risk their award to be set aside. But not because they used AI, but because they are wrong. And I want to give an example of non-AI hallucination, a recent case described by Global Arbitration Review. An award of a sole arbitrator was set aside because it was third award in a series of disputes of parties, and this arbitrator copy-pasted more than 200 out of 450 paragraphs in an award. Well, it's not a big problem. The problem was that the applicable law was different, the contractual clause was different, the parties were the same, and the legal problem was the same, only that the law applicable was unfortunately not. And this award was set aside in India because it was a case by an Indian arbitrator. So humans can hallucinate. And I can give an example from Poland. I remember very well that there is an existing jurisprudence of Polish Supreme Court based on non-existent judgment. Why? Because it was misquoted in the first commentary. It's actually the thesis, not the full text available. And it actually made other commentators and different benches of the Supreme Court to agree with the thesis that was actually not made in the judgment from the 60s, if I'm not mistaken. So can we hallucinate as humans? Of course we can. We can hallucinate with or without the use of AI. And in my opinion, the problem is whether we do. And the secondary question is why we do that. So, unless, and to finish up the challenges to awards issue, well, of course, if arbitrators delegate the decision making, so it's an award based on a prompt, this could be a reason for challenges. And in conclusion, I agree with what was said earlier this afternoon, that AI should and could be only a tool serving to help administer the justice, not adjudicate. And the current state of affairs is that arbitrators do not have a duty to consent, to obtain parties' consent, or even to inform them about the use of AI. And the mere use of AI is most likely not sufficient to challenge either arbitrators or their awards. And the challenge can be successful if they cross certain borders and the decision making is shifted to AI from human. But the final point is, I think, the most important. We need guidance in the gray zone. So what can and what cannot be done. And this guidance can be sought from a different body that will, again, prepare a set of soft law? I don't think so. I think that the parties and arbitrators need to sit down together and have an honest discussion what they expect from each other. If the parties prohibit the use of AI, then the arbitrators, if they want to adjudicate the case, they should agree with them. Thank you very much, and I'm looking forward to an interesting discussion afterwards. Thank you.
Thank you very much, Doctor. Please take the seat during our discussion. And now it's the time for discussion. First, I I would like to ask you to present your opinions, maybe to share your insights after these reports. Is there anybody who wants to look something? Yes, please, Professor.
Thank you. I don't know, is it okay if I speak without a microphone?
I hear it. The microphone is here. They have a microphone in the back.
Oh, yeah. Thank you. So thank you, everyone, for these excellent presentations. I'm wondering, and I keep wondering, how much sense it actually makes to distinguish between delegating the decision and simply having like assistance with the decision, because I wonder whether the boundaries between these two concepts aren't a bit fluid. Because if you get if you get an AI to prepare, in a sense, decisions, or if you can save a lot of time by preparing, then I wonder whether you can actually still check it, or whether there will be the expectation that you do much more, so you simply will not have the time to check. So that is why I personally think that you have to have the same guardrails for assistance that you also need to have for delegation. And the other thing is that I do not think that we can seriously talk about enhancing access to justice or quality or whatever in the current situation where all these strong AI tools are developed by actors that really are not very trustworthy, where we have no insight into how the training works, where it's, I mean, I don't even have this much problem with the lack of transparency, but with who develops these tools. So I'm wondering whether if we actually want enhancement of anything, whether that wouldn't require that we create a whole new industry in Europe that actually can produce this technology, because the current actors that are producing that technology, I don't think that they are interested in the ideals that we are talking about. Thank you.
Thank you. Is there anybody who wants to share his opinion?
So maybe just a quick reply. On the one hand, what we see, for example, in Germany is that they are trying at least to use open source large language models. I mean, I think they are still from China, as far as I know, but they are trying somehow to at least use something where they can see parts of the code. Maybe that's not the best solution. And regarding the access to justice, yeah, I'm not quite sure if it really will work at this moment or at this point. I just wanted to mention it because there was a recent study in Berlin about the access to justice, and they also mentioned the use of legal tech tools. And what we have seen, for example, in Austria, it's not enough to simply offer a chatbot with minimum functionality. I think you need more than that, of course. Yeah, 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 yeah. Yeah. And just one final remark regarding the distinguishing between preparatory work and or assistance to decision making and the decision making itself. I think this also derives from the AI Act. If we look, for example, at the exemption in Article 6, Paragraph 3, there is this difference between preparatory work, which is not a high-risk system, but of course, I think that this is a very important point to say that there is an expectation to do more work with AI, and this leads to less control, maybe by the judges themselves.
Thank you very much. Is there anybody else in the lecture hall? Yes?
So, yeah, I think I will start with the second remark. As you said, usually it's like we fine-tune the models that exist, right? So we take some open source models, like Llama, right? Or some Chinese models, and we fine-tune them. And this way we get rid of some biases, right? And but still they can be some biases internal, right? And like the one that we heard, that when you use Chinese model, for example, you cannot learn what happened on Tiananmen, right? So they are there, right? And we cannot be totally, sure that something like wrong is not there. So the best solution would be to train our models, right? But then we need thousands of GPU cards that work and a lot of energy also, right? And it's a bit against the European Union policy, right? Because of the environmental things and laws. So that's why China, USA, also having very huge companies, are much ahead of us, right? So this somehow limitation for the scientists, because we have quite good scientists in the Europe, but this limits us. But of course, I understand the limitation, but this way the technologically Chinese and USA is ahead of us. And going back to the first remark about the assistant, right, who tries to sum up something and then we decide, it's always the problem. But it's like with the human assistants as well, right? We need to somehow trust the assistant to know that he summed up what we wanted and so on. And here it's a smaller problem because we can personalize models, large language models. So after training the models, we can personalize using very small modification of ways to make the model more to model so that the model fits better to the person, right? And the person can say, I don't like that you have not put this into summary, right? And then we can, fine-tune it even better. And this way we can go into direction to the good assistant, right? The one that we would like to have. But this first problem that we talk about is more complicated.
Dr. Durbas.
Yes, and coming back to saving time, well, one of the risks of using this AI to draft the first version of a document, any document, procedure order or a word, is that it will omit something. Well, let's leave hallucinations aside, we can fact check them, but if we see that the procedure order looks good, there was a motion, we check, yes, there was such a motion, there was a reply, yes, there was such a reply, arguments, okay, and then we can decide. The risk is that there was some important argument omitted. I'm a disputes lawyer in Poland. Have I seen a non-AI generated judgment or award that omitted an important argument? Of course I have. Was it convenient for the judge? Of course it was. Whether I appealed? Yes. Was it successful? Not always. So I think it's an inherent element of using such technology, and I concur that it's a matter of trust. I think that we can share this trust initially to very simple tasks like labeling documents, translating, making a summary, and only then when we know it's safe we can use it for more complicated tasks like preparing some draft versions of documents. But like a simple communication to the parties, well, I think that most AI chatbots are already ready to do that.
Thank you. And Professor Emmanuel Gelard.
Yes.
Please.
Yes, thank you very much. It was very, very interesting, and I'm very sorry not to have been there to discuss. Can you hear me?
Yes.
Yes, we can hear
Yes,
you.
okay.
Yes.
Just a few remarks to follow up what my colleague said. In the French Court of Cassation report, they talked about the Mistral, I don't know how to pronounce in English, system, which is a European system. I don't know if it's something valid or not. Maybe our specialist of AI can answer. My second remark is about this problem of assistance, which is a human resources problem, because now we have a crisis connected with the function of clerk. And in France, at least, we have some strike by clerk because their function may lack of meaning. And so it's a danger much more for the clerk than for the judge at the moment. And we should be very careful with this kind of assistant of judges. I don't think it's an easy problem. Then about translation, we know we all experimented how powerful this instrument are for translation. But legal translation may be very difficult. I don't think that translation is as easy as it seems. If in one page there is only one word which is problematic, it's already a problem. So we have to be very careful with translation as well. And then, because we talked about to save time, the time to check a word or judgment and so on is going to be difficult, because it's difficult to check what is missing. My colleague was talking about that. Very difficult to check what is missing. It's more easy to check what is there but not correct and so on. And so for all these reasons, we need to have guidelines, but maybe we need to have cases. And I would like in the future to look at the future cases of different countries and to build up some rules on that. Would be very interesting. Thank you very much for your attention.
Thank you, Professor. And on the chat, we have got the suggestion to discuss 3 key ideas which could help shift mundane judicial duties and concentrate on engaging attorneys in focused oral trial sessions. And first is, AI is an assistant to automate administrative and repetitive tasks through artificial intelligence. Powered case management systems allowing judges to focus on substantive legal issues and oral hearings. This is the first question. Second, enforce strict evidence submission deadlines and send automated reminders to attorneys using AI, ensuring all materials are ready before the oral trial and reducing procedural delays. This is the second. And the third, adopt real-time AI transcription and live summarization tools for oral proceedings, which support efficient, accessible, and well-documented one-day hearings. So we have got 3 questions or ideas to discuss. Maybe one of our speakers wants to express his opinion in this matter.
Just one word, if I can.
Yes.
It's about all proceedings. It's not only in France, because I think it's in Italy as well. there is less and less oral proceedings for many reasons. I know that it's not the case in Germany and probably in Poland, but okay, to focus on substantive issues and oral proceedings, if there are still oral proceedings. So that's, for us at least, an issue.
Thank you. Yes, please, Professor.
I just wanted to add another point to the discussion about judicial assistance. I was also thinking about, in the preparation of my presentation, about comparing AI and judicial assistance. And I think one thing that distinguishes the situation is that we are, for example, in Switzerland and Austria, able to reject judicial assistant or law clerk on the basis of their impartiality, for example, and we don't have at the moment the same procedural measures regarding AI. And I think we have to discuss about something like that, how to, on the one hand, be transparent on that matter, on the other hand, if we maybe can find a solution that there is some form of rejection regarding AI assistance.
Thank you. Is there anybody else who wants to? Yes, please, Professor.
Yeah, I just wanted to fastly answer this question about Mistral. I think it's a very good, direction, and this is definitely the model that we somehow can trust, right? However, this model will always have, will be somehow worse than the models from China and the USA, because they use data illegally, usually, right? I mean, they often use data without to train the models, right? They use data that they don't have the full rights, right? For example, and many cases appear when people sue them for using, for training the data that they don't have property to, right? So maybe Mistral, because of the fact that Mistral is completely legal and use only the data that it can use, it can be less general, but it's definitely a better point to build on, and I definitely agree with that. Mm-hmm.
Thank you.
Thank you very much. There is no more questions. I can see. Oh, yes.
Thank you. Perhaps it won't be a typical question, because actually I have a question to one of the members of the audience, Professor Michał Krakowiak, who happened to be a judge as well, a tenured regional court judge. So I wonder, what are your expectations regarding the use of AI in judiciary as an active judge doing his job, administrating justice on a daily basis?
Thank you very much. I think for me, as a judge, civil judge in civil cases and familiar cases, it's important to use AI, artificial intelligence, as a tool to case management. It's very important for judges, I think. It's first of all. And I think it's important to artificial intelligence could be very good assistant, only assistant for a judge, I think. But we now in Poland civil procedure and in practice in civil cases, we are the first step about it. And I think it could be great. Thank you.
Thank you. Okay, I think that this is the end of our discussion, so I would like to ask Professor Andrzej Olaś to conclude all the conference and then closing the conference. But before, I would like to thank all the speakers in the panel too for very interesting reports. Thank you very, very much.
Thank you very much. I will be really brief, as I assume we all have a right to be a little bit tired after this really focused and long day here at the Jagiellonian University, discussing those issues which are truly recurring and those latest development in the administration of justice. I just want to say thank you to all of you, the participants, those who have contributed to our organization. I would specifically like to say thank you also to Mr. Rafał Wieczerzak, my PhD student. He did a lot of tremendous job in the preparation of this conference, so I really do appreciate his work. I'm very much grateful that we had this opportunity to meet here in Krakow. Today's day, as part of our scholarly discussion, is coming to an end. However, it's only just a pause. Our work never really ends, just like a development of social life, technology, as well as the practice of justice. And I hope that our proceedings were of value to those who were the active participants, to those who listened to our discussion. Once again, thank you very much. It was a great pleasure, an honor to have you there, and I really hope that we will have the opportunity to meet again here in Krakow and in other places around Europe and around the world. Thank you very much. Yeah. Thank you. So I think we may consider this conference as concluded. Yeah.